Morning members and welcome to this meeting of the Planning Applications Committee of Thursday 25th September 2025. This meeting is being live streamed and will be made available on the Council website for public viewing. For members and members of the public in the hall, can you please ensure that your mobile phones are either switched off or on silent? Thank you. Remote participants, please follow the good practice guidance, which includes muting microphones and switching off your video when you're not addressing the meeting, writing speak in the Teams chat function when you want to contribute. If you're in the hall, you can do this on your iPhone or iPad. Please don't repeat contributions already made by other members. No material should be posted in the chat function if it's intended as part of the discussion. The usual standing orders apply, including that any votes will be undertaken by roll call. If any member has to leave the meeting, please either leave the Teams meeting for that period of time or write leave in the Team chat function and then join when you rejoin the meeting so we can keep track on whether the meeting is quorate. All members should speak clearly and directly into the microphone when making contributions, and when referring to reports, please provide reference to the relevant page and paragraph to allow everyone to follow. Please focus contributions on areas where clarification is required or to propose an alternative to a recommendation. Similar to the process now followed at full council when considering motions and amendments which are substantive in nature, I will call a recess when necessary so that I may seek governance advice and competency. This is a good practice in governance terms and will also provide for governance to be able to collate and circulate the terms of the said motion amendment to members in order that they have the opportunity to properly review it. I hope this process makes matters more effective and I seek members' support in implementing this. The usual standing orders apply, including any votes taken by roll call. Tracy, our clerk, can you confirm Sedrent and I approve remote participation? Thank you.
Thank you, Chair. Good morning, everyone. Morning, members. We've got 12 members present in person, 6 members present here at Council HQ, being the Chair, the Vice Chair, Councillor John Campbell, Councillor Drysdale, Councillor Hislop, Councillor Johnston, and we've got 6 members present on Microsoft Teams, being Councillor Blake, Councillor Dryborough, Councillor Giusti, Councillor Jordan, Councillor Lowe and Councillor Thompson. One member not present at the start of the meeting is Councillor Hill, and we've got apologies from Councillor McFarlane, Councillor Marshall, Councillor Slater and Councillor Walters. Thanks, Chair.
Thank you very much, Tracy. Are there any declarations of interest, members? Councillor Drysdale and then Councillor Dryborough, please.
Morning, Chair. Good morning, members. Thank you very much. I wish to declare an interest in item number 7, Corbridge House, Milton, please, as I know a large percentage of the objectors, one of them being a relative, so I will leave the room when that item comes before us, Chair. Thank you.
Thanks very much. And Councillor Drysdale did ask about the misleading reports in the press. However, the information in the papers before us and in the documents circulated by the Council are accurate, and the information relates to Milton and not Crockett Ford. So I clarified that with the staff prior to the commencement of the meeting. Councillor Dryborough, please.
Thanks very much, Chair. It's very similar to that one on item 13. I want a point of clarification because there seems to be a misunderstanding of my role as the Armed Forces champion, in that I've got some form of responsibility for war memorials. That is not the case. I have got a responsibility to look after people, and I do that through different agencies that we've got working alongside the council. So if all of those individuals who think I have got a responsibility for war memorials, they don't know what they're talking about.
Thank you for that, Councillor Dryborough. If there are no other questions, I have one question for governance. On agenda item 12, page 194, paragraph 1.4, the report on that item says this is almost an identical application to one that was determined by the LRB, the local review body. Therefore, are we still, as elected members, able to consider this application, given that we have already made a decision on a previous one, although I accept that it says it's almost identical, which means there are changes, and I understand that every application be treated in its merit, but I think just for clarity, the LRB should be advised whether or no the members that addressed or dealt with that application are able to sit and deal with this one.
Thanks, Chair. Yeah, as you said there, that each application is dealt with on its own merits, and this is a fresh application with new information that's in front of members today. And as per the Code of Conduct, my only advice would be it's for each member to determine their own declaration of interest, and if you have dealt fairly and impartially with all matters involving the application, then that would not preclude you from determining the application. But as always, it's in members' hands, but that would be my advice. Thanks, Chair.
Thanks very much, Tracy. That's really helpful. Okay, if there are no other declarations of interest, can you outline the procedure to be followed at the meeting today, please, Tracy?
Thanks, Chair. The Planning Applications Committee will consider each application in turn as detailed on the agenda. The case officer or other appointed officer will make a short presentation addressing the determining issues accompanied by digital images. Any late information, amendments or corrections will be reported at this time. Members may ask questions of officers following the presentation on points of clarification. The Chair has been provided with a list of eligible representatives who have registered to speak at this meeting within the period specified in Council policy. No other persons will be allowed to speak. The Chair will individually invite those who have registered in advance to speak to make their presentation, after which they may be questioned by committee members. No questions may be asked of members. The order of eligible parties being heard will be as follows: third parties objecting to an application, third parties supporting an application, statutory consultees objecting to an application, elected members of Dumfries and Galloway Council who are not members of the Planning Applications Committee, and such members should withdraw from the meeting after making their presentation, and then applicants or their agents. Representatives were offered the option of attending today's meeting in person, joining remotely through Microsoft Teams, or to provide a written statement to be read out on their behalf. Presentations will be strictly limited to 3 minutes per person, except for national and major developments, which by their very nature are more complex, where the time limit will be 5 minutes. The Chair of the committee will ask you to come to a conclusion if you take too long. Representatives are encouraged to use the time allotted to clarify any points they consider material and address the determining issues. Certain matters are not normally material planning considerations and will not be taken into account by the Council when deciding on a planning application. Representatives should not raise any new matters without explaining why they were not raised earlier with the case officer. Please do not repeat what is in the report, as members will have already read the report. After all the representations have been heard, the meeting is then in formal session, and no members of the public may address the committee from the public gallery. The Planning Applications Committee will then proceed to determine the application. Thanks, Chair.
Thanks, Tracy. We go on to the agenda item 3, the minute of previous meeting of 27th of August 2025 for approval. Members, is this a true record, and are we happy to approve? You're going to correct that, are you? Okay with that? Okay, move on to agenda item number 4. An application from Fell Wind Farm site between Black Craig Wind Farm and Lochar, 7 kilometres to the southwest of Money Ive. An application for the erection and 35-year operation of a wind farm comprising 9 turbines, formation of access tracks, borrow pits, battery storage, temporary construction compound, substation and associated infrastructure, at variance with conditions 2 and 13 of application 22/0471/S42 to remove turbine 3 and allow the tip height of turbine 1 to be increased from 180 metres to 200 metres high. This is a section 42 amended description 25/0539/S42, and our case officer is Robert Duncan. Robert, will you take us through your presentation, please?
Thanks, Chair. Certainly, as per paragraph 1.6 of the report in front of you today, which is on page 24 of your papers, this application is made under section 42 of the Town and Country Planning Scotland Act of 1997 as amended, and it seeks a new planning permission for the proposed wind farm development at Fell, but with two different conditions, at variance with appeal decision PPA 170-2163, and those two conditions are conditions 2 and 13. So in greater detail, as per paragraph 1.12 of the report, which is on page 26 of your papers, the applicant has confirmed that this application seeks consent for a different layout plan and infrastructure position beyond that which is possible under the terms of the present condition 13 to the aforementioned appeal decision, and the prospect of proposed turbine 1 being 200 metres from base to blade tip instead of 180 metres, as set out in present condition 2 to the same appeal decision, that is PPA 170-2163. Supporting information has been submitted by the applicant to try and show that the impacts arising from the revised version of the proposal made possible by the varied conditions sought would not give rise to significant adverse environmental impacts and should be supported on that basis. The current application seeks micrositing consent of more than 100 metres for a number of the approved turbines and infrastructure. The application is supported by the information set out in paragraph 1.13 of the report in front of you, and that's on pages 26 and 27. This slide is showing the planning history relevant to the proposal, and it reflects the information contained within the report at paragraph 1.14. So that's on page 28 of your papers, but this is in reverse order, so what you're looking at is oldest to most recent, whereas I think it's the reverse order in the report, just to confuse matters slightly. The cumulative situation is shown on the slide here in front of you. It shows approved wind farm decisions in the wider locality. These are not necessarily implemented as things stand. I've undertaken a review of the determinations listed and shown on the screen here insofar as they're located in Dumfries and Galloway in respect of specific micrositing allowances set out in the conditions, and I've arrived at the following conclusions. So the Blackcraig Wind Farm, which is 05N25, which is very close to this proposal, there was a micrositing allowance of 30 metres under condition 3 of that consent. Droston Loch, the micrositing allowance was 50 metres. Glen Shimmerich, the micrositing allowance was 100 metres. Margree, the micrositing allowance was 100 metres. Margree, again, it was slightly different this time. That was 130 metres, and that was considered by the case which was in front of you earlier this year under section 42 of the Act. Divot Hill, micrositing allowance of 100 metres. Weather Hill, 30 metres. Manwhill, micrositing allowance of 100 metres, and the same for Cornharrow. The Lorg permission that you see on the screen had a micrositing allowance of 50 metres, as did the Shepherd's Rig section 36 decision. Windy Rig 20 Shilling also had micrositing allowances by condition of 50 metres. Whiteside Hill was 30 metres. Sanker 2 had no limit with the agreement of the Planning Authority. Benbrack was a micrositing allowance of 50 metres. Windy Standard 1 was 90 metres, with Windy Standard 2 and 3 having micrositing allowances by condition of 50 metres. So that gives you a general kind of overview of previous casework that's relevant and fairly local to this case. This shows the site layout granted under appeal decision PPA 170-2163. This appeal was submitted to the Scottish Ministers on the basis of non-determination of the application by the Council on the 31st of August 2022. It was determined by Scottish Ministers on the 10th of March 2023. It was granted subject to conditions. Members should note this remains an extant planning permission, so that means it can be implemented. Recent decision that I referred to, sorry, it was a different one earlier this year to the one I'd mentioned previously. It was 250141S42, served to extend the window for commencement of the development. I think that was at committee in April this year until the 2nd of November 2029, and that was reflective of the fact that there were difficulties in connecting to grid infrastructure within the timescale of the planning permission. So the point here is that there is a fallback position, and the determination that you'll make today does not affect that situation. The next slide I have is the revised layout sought as part of this application. So it should be noted that this layout cannot be implemented under the terms of the existing appeal decision that I've mentioned, PPA 172-163, or the recent planning permission 25014-S42, due to the wording of conditions 2 and 13, which, as they are at the moment, are set out within the report at 1.10 and 1.11. So that's on pages 25 and 26. Scottish Government guidance in relation to Section 42 planning applications, that's summarised within the report in front of you at paragraphs 1.3, 1.4, 1.7, 1.8 and 1.9. And this is contained within Scottish Government's Planning Circular 3 of 2022. I think the key things really are what appears in paragraph 1.4 of the report on page 27. And it says, Annex H of Planning Circular 3/2022 provides that applications made under Section 42 of the Town and Country Planning Scotland Act 1997 as amended are applications for a new planning permission or new planning permission in principle for a development, but with different conditions from those that attach to a previous permission for that development. I think the other thing is also key is at paragraph 1.8a, and that's at the foot of page 24 in your report, where it says, in determining a Section 42 application, planning authorities may consider only the issue of the conditions to be attached to any resulting permission. However, in some cases, this does not preclude the consideration of the overall effect of granting a new planning permission, primarily where the previous permission has since lapsed or is incapable of being implemented. And as discussed, you're not in that situation today. So moving now to the recommended conditions and reasoning and justification. Condition 2, the recommendation is to vary this condition to allow an alternative site layout to be submitted and approved with the agreement of the Council's planning authority, and this could be achieved by a discharge of conditions application in due course. The revised layout arrangement tabled as part of the application has encountered difficulties with SEPA, and you've got the SEPA comments in your report as well at section 2. The recommended condition wording also makes it possible for the applicant to implement a development of 9 wind turbines, each up to a maximum height of 200 metres at this location. Turning to condition 13, the recommendation is to vary this condition to a degree which would be consistent with other wind farm developments in the locality, including recent decision 25021-S42 at Margrave, and not present a significant change to the terms of the substance of the permission, such that it would be tantamount to a material change to the application. So in other words, a 130 metre micrositing allowance is considered not too big a variation from the original environmental statement upon which the appeal decision rested. It also caters for consultation with SEPA in respect of any proposed revised layout, and again this could be achieved by a discharge of conditions application in due course. The concern in relation to the submitted revised layout that has been tabled by the applicant is that it is too significantly different from the originally approved and condition layout and supporting information, and the micrositing allowance required to facilitate it does not accord with other similar decisions in the locality. And as per paragraphs 4.18, 4.19 and 4.20 of the report, on page 42, the recommendation in front of you is to grant planning permission subject to the conditions set out below, including the proposed varied versions of conditions 2 and 3. I would add that if members are minded to support the recommendation today, it would be open to the applicant to submit an application to discharge conditions 2 and 3 of the resultant planning permission in accordance with their terms in due course, and or submit an appeal to the Scottish Ministers in respect of the decision taken if they're unhappy with the conditions themselves, and or to submit a revised Section 42 application. Quite happy to answer any questions arising, Chair.
Thanks very much, Robert. Questions for our case officer? There do not appear to be any, so Councillor Drysdale, please.
Thank you very much, Chair. We do seem to have quite a lot of issues with this case, Robert. So, we're listening to the community and the citing of this, and the community are extremely disturbed and upset because they feel there's been so many applications, which we've mentioned at previous planning committee meetings with this energy contour as a company. So I just wanted to ask you, possibly through yourself, Chair, and through Laura as the legal team, with regards to the environmental damage, the peat damage with one of the turbines, the increase in height affecting the landscape in the Dark Sky Park, you've quite clearly stated that we can't object because it's a Section 42, but do we as a committee have any legal standing here with regards to perhaps discussing when we go into session some way to ask this company to bring it back as a fresh application? So it was really just to go through yourself and the legal team to ask if, as a committee, should we be minded when we get into the discussion where we can go on that when it is very difficult, because there have obviously been so many objections and it does affect the whole region because of the actual siting of it and the proximity to all the other wind farms which you've so rightly put up on the screen before us today. Thank you very much, Chair. Thanks, Robert.
I'll ask Laura first, because my understanding is any existing permission cannot be changed. We cannot request a revised application to come for us where we might refuse it. However, it has already been granted, and that's, as I understand it, full and final. But Laura, can you help first, and then I'll go to Robert.
Thank you, Chair. Yes, you're absolutely correct. As this is purely a Section 42 application based on the conditions themselves, unfortunately that's all that we can look at today. There has been case law to suggest that you can look at the wider implications if the underlying permission is no longer able to be performed, but my understanding is that's not the case here. There is an extant permission that the developer could go back to.
Thank you. And then Robert, and then Pauline wants to come back again.
Thanks, Chair. I think the key thing is in the report in relation to this point at paragraph 1.8c, and that's on page 25, where it says, if it is considered that planning permission should be granted subject to the same conditions as the previous permission, the Section 42 application should be refused. Making, granting or refusal of a Section 42 application does not alter or affect the previous permission or its conditions. So you've got a recommendation in front of you, and there's a form of words for conditions 2 and 13, but you do have the option of effectively refusing the Section 42 application if you don't want to amend them, essentially. That's the advice set out in the circular.
Thanks for that, Robert. Pauline, Councillor Drysdale.
Thanks very much, Chair. Thanks, Robert. I suppose I need to be frank. I'm still having, as is the community, quite a lot of confusion with regards to this application. So can we just 100% clarify what we are saying here is that we can either refuse it, but does that mean it then goes straight to the Scottish Government to determine it as it stands? Or can we perhaps put in different conditions with regards to the damage to the peat and the height of the turbines? I would probably need to go through Laura again for that. So just if we could be 100% clear on this so that we can go forward when we go into session. Thanks a lot, Chair. Thanks, Laura.
Thank you. As I understand it, we don't need to go back to the Scottish Government. Permission exists. We can't take that away, but I'll ask Laura, because we can't spend too much time on semantics. We have a very specific item we're addressing today, not the entirety of the application for the wind farm. Laura, can you just clarify exactly what we're doing today, please?
Thank you, Chair. Yes. Through yourself, Chair, if the members were minded not to grant the application, then it would be possible that the developer could challenge that on the basis, just like any application, if we haven't used sound grounds or reasonableness through judicial review or appeal, they could challenge that as any application in front of you. It wouldn't go to Scottish ministers as in the consultation. It would be the usual process of them challenging a decision of the Planning Application Committee. But on the question of trying to introduce conditions that they have not asked for, that they have not asked to be varied, the danger with that is that you're going beyond what the legislation says that you can do, and also the guidance. You should be restricting yourself to looking at the conditions that they have actually put forward as wanting to be changed. And again, if you were minded, instead of refusing it but granting it with different conditions, that would be open to challenge by the developer.
And just to be absolutely clear, if we refuse this application today, do ministers, Scottish ministers, have to be involved, or is that decision already made and can't be changed anyway in terms of the approval that's been given for the application site?
It would go to Scottish ministers if it was an appeal against a decision that you had made.
I think what Councillor Drysdale is trying to establish is if we refuse it today, does the whole application go back to Scottish ministers? And I don't think it does. I think it would only be the conditions we refused today.
Yes, Chair. If members refused it today and either an appeal was made or there was a judicial review challenge, it would purely, that second forum would purely be looking at the decision you made today as to whether that decision should be upheld or not. They would not reopen the original application for a development.
That's, I think, what Councillor Drysdale was trying to establish. That's done and dusted and can't be changed. Any other questions for our case officer? In that case, we go to a registered speaker. We have a statement from Trevor Proctor on behalf of Help Save Morecambe Fell Group. And we have 5 minutes because it's a national application or a major application. So can you read out the statement, Trace, when you're ready, please?
Thanks, Chair. So Trevor Proctor, and that's objection. We strongly object on behalf of the 196 members of the Help Save Morecambe Fell Group. Consent for the Fell Wind Farm was based on details specified by Energy Contour and their optimal design. No further changes should be allowed. Energy Contour have submitted 5 incremental Section 42 applications when a completely new application should have been required. Turbine 1 is closest to Loch Ar, increasing Turbine 1 from 180 metres to 200 metres high has the most negative visual impact on this valuable tourist attraction, making Turbine 1 even more overpowering and out of scale. Moving the positions of 4 turbines place these turbines closer to hill summits at higher AODs, making any previous permission invalid, as the viewpoints and visibility are all negatively affected. Condition 13 states clearly that consent is based on the infrastructure being sited exactly as shown on the site layout. SEPA objects due to excavated peat for Turbine 5, peat storage and the use of peat deposited for bunds and covering burrow pit excavation. GWTDTEs could be significantly affected by socio-siting changes. These have not been investigated. As protected species, these should lead to automatic refusals. For the adjacent Jarcogro wind farm, the CLA stated the Fell turbines will be 200 metres. In my opinion, the scale of the Fell turbines is regrettably in terms of achieving a good fit with the foothills, LCTs 18 and 18A landscape, and also the impacts of aviation lighting, an inherently dark area. Energy Contour have submitted a further Section 42 application to increase all turbines from 200 metres to 220 metres. Please stop them from gaming with the planning system yet again using multiple incremental Section 42 applications to achieve the exceed of their original refused scheme. If this was a new application for 8 turbines of 220 metres against a baseline of 0 turbines, would it be approved? Please refuse all these Section 42 applications.
Thanks very much, Trace. So members, you've taken note of that. There are no other registered speakers, so we're in session. Councillor Hislop, please.
Chair, can I just have clarification as what we're actually allowing here, because we've got 2 sets of recommendations. One says you can go up to 200 metres, but figure 3.2 is 108 metres. Another one says turbine 1's 180, the amended one that came forward. Are we allowing the 200 metre tip at turbine 1 or not? Because I'm kind of confused by that one. One's saying yes, but turbine 1's to be 180. Another one's saying that both parts are 180 metres. Which is the right condition?
I'll ask Robert to help. Robert, please.
Thanks, Chair. The recommendation is in your papers. Let me just check my notes here. I think it's on page 42, but I'll just double check that just now. Yeah. The recommendation's at the foot of page 42, so that's to approve it subject to conditions. So you've got condition 2, which says the development shall be implemented in full and strict accordance with the following figures 3.1 to 3.12 contained in, then it goes on, and then it says at the top of page 43 as part of that recommended condition 2, for the avoidance of doubt, the planning permission allows the siting of 9 turbines, each with a maximum height of 200 metres to blade tip. So that's what's allowed. That's effectively the change to condition 2 that's recommended. So it does allow an increase essentially in the height of one of those turbines. When you look at condition 13 that's recommended, which is on page 47, it's basically saying the wind turbines, tracks, crane pads and substation compound shall be erected in the position shown in figure 3.1 site layout in volume 2 of the environmental impact assessment. So that's the original environmental impact assessment that was considered at the appeal decision, unless the planning authority has given written approval for any such variation in consultation with SEPA. So there's a safeguard there that you're consulting with an appropriate body, because there's various issues that could arise. Any such variation, micrositing shall not exceed 130 metres in any direction. Now in the appeal decision, that condition is 100 metres. So it's allowing, recognising the difficulties they're having in getting a layout to work, it's allowing an increase in the micrositing distance from 100 metres to 130 metres. So those are the 2 recommended changes, if you like, to the appeal decision conditions.
Councillor Hazlitt, we want to come back in.
Chair, I'm not sure what was on the computer one, but I received a hard copy of the one that was sent out to us, signed by Mr. Valiente, and it quite clearly states this is the amended conditions, and turbine 1 maximum height of 180 metres to blade tip, and for 8 turbines 2 to 9 to be 200 metres. Now I'm not sure if that's the same as what's on the computer, because I don't have it in front of me, but also...
Before you go any further, Councillor, you're dealing with item 5 when you're reading the paper from Mr.
Agenda
Valente.
item 5.
We're on 4 at the moment.
Oh, that's maybe why I've got a problem. But within the 4 one, it also says that we're agreeing to 3.1 to 3.2 figures, and it says figure 3.2, typical turbine elevation, 180 metres. So does that part need to be changed to, because we're not abiding by the actual drawings now?
The application to change one turbine height
Yes,
and
but
change
the condition,
micrositing.
the condition at 5, condition 2 says the development shall be implemented in full and strict accordance with the following figures 3.1 to 3.12. Figure 3.2, typical turbine elevation 180 metres. Does that need to change also?
Robert, please, or David, if you want David to deal with it. But Robert, it's you.
Yeah, I'm quite happy. It's just basically replicating the condition within the appeal decision. So the cross-reference to the documentation is the documentation that was considered at the appeal. And the change there, like I've pointed out, is in relation to it now allowing 9 turbines, each of up to 200 metres base to tip. Item 5 is different, because item 5 isn't seeking any changes to that part of condition 2. So what you're looking at, for the avoidance of doubt, the documents listed in recommended condition 2 are those relating to the original appeal decision, and I'm just taking it forward. So it's not relating to the new proposed layout. This is back to the original information, if you like.
Councillor Hazlitt.
So if we put the old condition on the new application, they must abide by strictly, I think that's what it says, figure 3.2, which is 180 metres.
I think we've been asked to change that condition.
Yeah,
I
so
understand
should we
that,
not
don't
just change that in the actual condition to the new turbine?
Robert?
Because it quite clearly says there's 2 different turbines, whereas we're just having 1 turbine now.
Robert?
Yeah. Thanks, Chair. The wording of condition 2, again at the foot of page 42 and the top of page 43, does require it to be implemented in full and strict accordance with the information you've suggested. And then it says, except insofar as further details are required under the terms of the conditions attached to this permission, or unless otherwise agreed in writing with the Council's planning authority in respect of site layout. So it does allow a different site layout, and that kind of tallies in with the different micrositing allowance that's allowed. So in other words, they are having difficulties getting a layout that will work. The recommendation is to increase the micrositing allowance so that something which isn't too far away from the original permission can be agreed. The other thing is to clarify the maximum size of turbines allowed, and again that follows the appeal decision, but it changes it because the recommended condition says that for the avoidance of doubt, the planning permission allows the siting of 9 turbines each with a maximum height of 200 metres to blade tip. But again, that needs to be agreed. The actual proposed turbine type needs to be agreed in writing as part of the discharge of conditions after the decision is taken.
Thanks, Councillor Hislop. Councillor Driver, please.
Yeah, thanks very much, Chair. And you know, it's one of these things that I'm not happy with this, but I think we've got problems if we don't agree the recommendations within the report, and I'm sure that's not going to please a few people within the planning application. So I'm going to put a motion forward that we agree the recommendations within the report.
Thanks very much, Councillor Driver. Are there any alternative views? In that case, Councillor Drysdale, please.
Yeah, thank you very much, Chair. And I appreciate we're in a really difficult situation. We still haven't updated the grid infrastructure, and we're not looking at that until 2029, no matter how many wind farms come in front of us. So a lot of the wind farms in Dumfries and Galloway are going to be sitting static until we sort the grid infrastructure out, and we are awaiting the outcome of the public inquiry, the Scottish Government, which commences on Monday, due to the feeling in our communities at the moment and the discussions about moratoriums, etc. And I appreciate that's for every wind farm application, not just for this one in front of us. So I do have issues with this. I think, you know, we all look to protect our environment and look towards the future, but I would propose a motion that we refuse this Section 42 application, primarily due to the height and the peat and the infrastructure. But my wording would be, and I'd have to seek legal governance, Chair, but I would suggest that I present a motion to refuse this Section 42 application due to the environmental impacts on the Dark Sky Park, the detrimental landscape impact due to the increased turbine height up to 200 metres, when it was originally 180, of course, and the impacts in and around Locher due to the increased height of the turbines, and also the effects and detrimental effects, rather, of the cultural heritage to tourism, and also the cumulative impacts on the environment. So that is my motion, and I'm not sure if it's competent or not, and would seek governance on that. Thank you, Chair.
Thanks very much, Councillor Drysdale. I'm sure Mr Sutty will help.
Thanks, Chair. If you are minded to refuse it, I would suggest that really what you're looking to do is be very focused on the specific issues with the conditions which have been applied for, namely conditions 2 and 13. So any refusal, I would suggest, really has to be focused around that rather than the principle of the development.
I think Councillor Drysdale did say the impact of the additional height and the micrositing. I presume that would be a reasonable reason to submit for a proposal for refusal.
Yes, as long as members are comfortable with that. Laura? Through you, Chair.
I'll ask our legal advisor. Laura, please.
Thank you, Chair. I did note that Councillor Drysdale had said that it was due to the increased height of 200 metres. Where I would caution is that we would have to be quite clear why it is that one turbine being increased to that height is going to cause all this detriment, and what factual basis do we have for that refusal? What is it that you have seen in front of you that makes you think that one turbine being increased to that height when there are already other turbines?
Councillor Drysdale.
So coming back in, I'm assuming I'm taking the advice of the Chief of Planning this morning, and I would only be able to legally object on 2 and 13. Is that correct? Because it
2 and 13 is what we're dealing with here, so that's
Yep.
all you can object to.
Yeah. Mm-hmm. Okay, well, I need a few minutes, if that's okay, to write this. I don't know if we're allowed to call a recess, because I need to log into my laptop to send this to Tracy, the governance officer.
Okay, 5 minutes.
Thank you, Chair.
Members content with that?
Thank you, Chair.
Councillor Drysdale. Hopefully Tracy will put it into the chat. Hopefully we'll see it on screen. There it is in my right and left. If members want to see it. Okay, I shall ask legal and then Mr. Sutty, or Mr. Sutty and then legal, to advise me whether or not that proposal is competent. Legal, please, Laura Whitelaw.
Apologies, Chair, I don't think I've received the text. Sorry, Chair, I have difficulties reading that. Would it be possible for that to get forwarded to me? Sorry.
Member will get it in Teams chat function. Whilst Laura's studying it, David.
Chair, as I say, to be competent, I think it would really have to demonstrate that, given what already is extant, that this additional 20 metres is going to have such a material change, and that the micrositing of 30 metres is so material that it's above and beyond what's already valid, alive permission just now. I have to be honest, I'm not sure I see something there which does that, but I'm happy to be advised by Laura on that when she's had a chance to read it.
And for folk that are looking at that, what does the acronym mean?
So, sorry, that's the acronym is then spelled out beneath, which is Dumfries and Galloway Wind Farm Landscape Sensitivity Study, which was adopted by the Council early this year and forms part of the supplementary guidance on wind energy.
Thank you. Laura, have you time to reflect on that proposal?
Thank you, Chair. Yes, I would agree with David that there is a risk that that would be challenged on the basis that it's not based on sound grounds. We have to be very careful that all that is being asked for here is one turbine is to be 20 metres higher, and we would have to be really quite careful that there is sufficient grounds in front of us to justify what is being said there, that extra 20 metres on that one turbine is going to have the impact that it says, and be in a position that if this was appealed by the developer, that we would be quite comfortable to take a factual position on that.
Okay. Pauline, do you still want to, Councillor Drysdale, do you still want to present that given the advice you've received?
Well, it's a very difficult situation that it puts upon us here as a committee, because we've also got on page 34 the fact that the tracks will have to be amended. So I don't know if that gives me any traction here, excuse the pun. The fact that all the tracks that are going to have to be put in for this proposal are all over areas of deep peat. We're creating, this wind farm is creating a huge impact on our landscape here up at Lochar in the back of Money Ive and up behind Corsic. But we seem to be, our policies within the council are to protect our environment, but we're going to be attacking the peat again, which is one of the issues that we are fighting against, or our communities are fighting against. So I don't know if that gives me any further
You're
ability.
drifting away from the application, Councillor Drysdale, which is only for micrositing and height. It's nothing to do with peat restoration, peat preservation tracks. It's only two elements that this applicant's looking to change. He's got, or they have, micrositing 100 metres, one additional 30 metres, so that they might protect some peat if they come across peat, and 20 metres additional height. So you can't introduce anything else other than micrositing and height.
Okay, so we're saying here that the motion is not competent. Is that right? Through yourself, Chair, and through legal, Laura, you're saying it's not competent because the applicant would be able to come back and that would cost the council dearly, in effect. So I have no grounds to put this motion forward. Is that what we're saying? Thanks, Chair.
Thanks, Councillor Drysdale. And I wouldn't want you to say it might cost the council, because if we feel strongly about something, we should make that decision in respect of what the cost might be. I think what we're being advised is that it is not, or it would not appear to be a reasonable decision based on the fact that the only change will be 20 metres on one turbine. I think that's said by Sure Receiving. So declare it not competent and move on. I have a proposal from Councillor Dryborough. So, did you want to come back in, Laura, our legal advisor?
Thanks, Chair. Through yourself, it's maybe just semantics, but it's on the use of the phrase competent. It's not so much the competency, it's whether or not you have got sufficient grounds to be able to justify yourself if you were asked to lead evidence on that at an appeal. If you feel that from what you have read, you are able to put forward an argument to substantiate, it could be that one turbine, with it being 200 metres, that would make all the difference. And if you feel that you have read something in the papers that supports that, then it is not that your motion is incompetent, it's that you have to feel comfortable that at an appeal setting you would be able to answer questions on that, what had led you to that belief.
So it appears my information is wrong. You can present that proposal if you wish, Councillor Drysdale, but you would maybe be invited to a public inquiry to speak to it if it was successful and the Scottish Government had it called in. But while you're contemplating that, I'll come to Councillor Campbell.
Yeah, thanks, Chair. Good morning, everyone. Would it be possible to see where turbine 1 is on the location plan, if we can get that up? I mean, it's obviously causing quite a bit of controversy, shall we say, but, you know, if we can get that sort of location up, maybe that would help members as well. Thank you.
Okay, can we do that? Fiona, please.
Thanks, Chair. I'm just going to zoom into this image that I've got, which is the same as this one. This should say site layout granted under appeal decision PPA 172-163. So that's the right, sorry, in terms of which is turbine 1. You're looking at the northernmost turbine in this layout, which is the one which is broadly in the centre of that. So slightly to the north west of turbine 13, you've got T1 turbine 1, and that, like I say, it's the northernmost out of the proposed turbines, so that is the T1 that's in question here.
So is that next to the wooded area? It's not very clear up there.
Yeah,
on the screen.
the wooded area is just on the left of that turbine, Councillor Campbell.
Thanks, Chair.
Okay, folks, we have to move on. Councillor Drysdale.
Okay, I am going to put my neck on the line here because I feel quite strongly about it. I do think our communities are not being listened to. We have to, as councillors, listen. That is what we have been elected to do, Chair. So I am going to stick to this motion if it's not incompetent, because T1, which is the turbine that is being requested for the increased height, is 20 metres. This is right next. It has the most visually negative impact on this valuable tourist attraction. And this is an area that's accessible to people of all abilities in the west of the region. The height increase would make it even more overpowering and out of scale. And a lower turbine was initially chosen to lessen the height increases and the impact of that on Locher and the surrounding area. So I think the micrositing and increasing that particular turbine height, which will not go into the grid for a long time to come, and it won't actually assist or help anyone within our communities. And I know that's not a material consideration, but we have to listen to the objections that have been made by the local community council. So I'm going to stick to my proposal, and if it's just myself, I'm happy just to put that forward. Thank you, Chair.
Thanks very much, Councillor Drysdale. So I have Councillor Dryborough, who has put a motion up to go with the officer's recommendation, and I have a motion from Councillor Drysdale for a refusal on. I'm looking for a seconder for either. Councillor Campbell.
Yeah, thanks for letting me back in, Chair. Yeah, no, it was helpful looking at the location plan where turbine 1 was, but looking at that, there was almost 4 or 5 in roughly about the same sort of area, and I don't think one being at 180 and 3 or 4 of them being at 200, they will stand out anyway. So I'd be happy to second Councillor Dryburgh to approve subject to conditions that that goes ahead.
Thank you, Councillor Campbell. So I'm looking for a seconder for Councillor Drysdale. You appear not to have a seconder. Do you want to record your dissent, Councillor Drysdale?
Yes, thank you very much, Chair. I'll record my dissent. Thanks.
Thank you very much. Given that there's no seconder for Councillor Drysdale, the decision is to approve the application as per officer's recommendation. Can you confirm your decision, please, Tracy?
Thanks, Chair. Members have approved the application subject to the conditions detailed in the report, and I have noted Councillor Drysdale's dissent. Thank you.
Thank you very much indeed. We move on to agenda item number 5. An application for Firle Wind Farm site between Blackcraig Wind Farm and Lochar, 7 kilometres to the southwest of Money Ive. An application for the erection and 35-year operation of a wind farm comprising 9 turbines, formation of access track or tracks, borrow pits, battery storage, temporary construction compound, substation and associated infrastructure at variance with conditions 2 and 13 of application 22/0471/S42 in brackets A, to allow changes to the ancillary infrastructure out with the consented micrositing allowance, and in brackets B, to increase the stated micrositing allowance to 130 metres to facilitate development of the wind turbines, and again in brackets amended description 25/0647/S42. And again, our case officer is Robert Duncan. Robert, will you take us through your presentation, please?
Thanks, Chair. Happy to do so. The first thing I'd like members to note is that recommended conditions 2 and 13 contained within your report at pages 75 and 79 respectively should be amended. And this has been due to a production process problem. I'm now aware that a supplementary pack has been issued by the committee clerk which provides this correction, and I'm very grateful to her in that regard. Saves me a bit of reading from my presentation, so I'm not going to read out the revised recommended conditions 2 and 3 because that's superfluous now. You've got it in front of you. You can all read what's there. Turning now to the report at page 62, paragraph 1.6. Again, this is a section 42 application. It seeks a new planning permission for the proposed wind farm development, but with 2 different conditions. Variance with the same appeal decision, PPA 172-163, and these conditions being 2 and 13. So the greater detail of the proposal is at 1.12 of your report. So that's on page 64. Again, I'll not read that out for the sake of brevity. I'll just leave that with you just now. The application is supported by the information set out in paragraph 1.13 of the report in front of you today in pages 64 and 65. So in many ways it's similar to the previous application you considered under item 4. The planning history on your screen reflects the information contained within the report at paragraph 1.14 in pages 65 and 66, but again ordered from oldest to most recent determination. This is an overview of the cumulative situation showing approved wind farm decisions in the wider locality. I mean, as was taken up in the previous debate, a lot of these haven't been implemented yet, mainly due to grid connection issues. I won't read out the specific micrositing allowances set out, but again, I have looked at that, and there are varying conditions relating to micrositing, but I would like to draw to your attention the decision taken in relation to Margree 25/0218/S42, which allowed a micrositing allowance of 130 metres, and that was a decision taken earlier this year. So there is precedent there to go beyond the 100 metres micrositing allowance, if you like. This is the site layout granted under Appeal Decision PPA 170-2163. Again, this appeal was submitted to the Scottish Ministers on the basis of non-determination by the Council on the 31st of August 2022. It was determined by Scottish Ministers on the 10th of March 2023 when it was granted subject to conditions, and this remains an extant planning permission, so could be implemented. Recent decision 25014 on S42 at Fell served to extend the window, as I call it, for commencement of the development until the 2nd of November 2029 due to grid issues. So there's a fallback position, and the determination made today does not affect that situation. The revised layout sought as part of this application, it should be noted that this layout cannot be implemented under the terms of Appeal Decision PPA 170-2163 or recent planning permission 25014 on S42 due to the wording of conditions 2 and 13, which are set out within the report at 1.10 and 1.11. It's come to my attention since the report was drafted. I had been under the belief that a 130-metre micrositing allowance would allow this amended layout to meet with the terms of that condition. It now turns out that it can't, but I feel I've got to strike a reasonable balance here, and I think a micrositing allowance up to 130 metres is that. However, I do acknowledge that this means that this version of the layout that they would like to implement can't be implemented under that condition. Again, Scottish Government guidance in relation to Section 42 planning applications, that's in Annex H of Planning Circular 3 of 2022. It's also within your report at paragraphs 1.3, 1.4, 1.7, 1.8 and 1.9. And now moving to the recommended conditions and reasoning. Condition 2, the recommendation is to vary this condition to allow an alternative site layout to be submitted and approved with the agreement of the Council as Planning Authority, and that could be achieved by a discharge of conditions application in due course. The revised layout arrangement tabled has encountered difficulties with SEPA, and members should note that no change is sought to the height of the proposed turbines within this application. So there's nothing in this condition relating to that. I think that again, that came up in relation to the previous item. So it's not seeking a change to the height of any of the turbines in the appeal condition effectively. Condition 13, the recommendation is to vary this condition to a degree which would be consistent with other wind farm developments in the locality, including the recent decision 25021/S42, which is the one I was talking about at Fell, and not present a significant change to the terms of the substance of the permission, such that it would be tantamount to a material change to the application. In other words, a 130-metre micrositing allowance is considered not too big a variation from the original environmental statement upon which the appeal decision rested, and that's the environmental statement that's quoted in recommended condition 2. It also caters for consultation with SEPA in respect of any proposed revised layout. So SEPA would be able to look at things like peat, for example, impacts on peat and groundwater dependent terrestrial ecosystems. And again, that could be achieved by a discharge of conditions application in due course, and the applicant is aware of that. The concern in relation to the submitted revised layout that has been tabled by the applicant is that it's too significantly different from the originally approved and condition layout and supporting information, and the micrositing allowance required to facilitate it does not accord with other similar decisions in the locality. So as per paragraph 4.7 of the report on page 74, the recommendation in front of you is to grant planning permission subject to the conditions set out in your supplementary pack, including the proposed varied version of conditions 2 and 13 that I read out earlier. So those are the ones in the pack. The other ones that are recommended in the report don't need to be amended. It's just 2 and 13. Again, if members are minded to support the recommendation, it would be open to the applicant to submit an application to discharge conditions 2 and 13 of the resultant planning permission in accordance with their terms. They also have the right to submit an appeal to the Scottish Ministers in respect of the decision taken. You can appeal against conditions imposed if you feel they don't meet the 6 tests set out in Circular 4 of 1998. So they may opt to do that, and at the same time they could also submit a revised Section 42 application. I don't have the power to refuse to entertain applications that are submitted. I hope that helps, Chair. Happy to take any questions arising.
Thanks very much, Robert. Questions for our case officer? There, Councillor Hislop, please.
What's deemed a material change Because my understanding, we're actually looking at 8 turbines instead of 9 now, is that correct?
Robert?
The applicant has said in their, this is where it gets slightly complicated, that they're proposing to delete one of the turbines, which is basically subtracting a piece from what they've already got permission for. You can't really do that through a Section 42 application because it's changing the substance of what the application is about. So even if they want to, you can't take away part of your planning permission by condition. You know, and expect the planning authority to do that because, in my view, that would be unreasonable. For a start, the complicated thing is obviously they could discharge the layout condition if they get permission at a later stage, and then if they wanted to go for an 8 turbine layout, we could agree to that, but we can't take it away from the description of the development because that's the substance of the case at this point in time.
Councillor Isaac, you okay with that? I take that as a yes. Councillor Drysdale.
Thanks very much, Chair. Coming back in again with the 59 objections to this application again, the two seem combined, but you know, they're back as Section 42s. We need to really concentrate on the concerns about the risks to human and animal health. We're back to the peat and
Is
the
this a
fact.
question for the case officer?
Yes, I just want to ask Robert, if you don't mind, Chair, thanks. The peat in the soil will be disturbed and possibly release environmental and health issues with the Chernobyl fallout, as we see on page 71, the first point I. And when we go to the conditions, Robert, I see that the development that SEPA will put in some sort of alongside Nature Scot, but that's for the decommissioning and restoration and aftercare strategy. Have we got enough in page 77 on 9 that we are confident as a council that we will protect the public with regards to the peat that's going to be disturbed during this construction, etc.? Because it just to me isn't quite clear enough, and we need to make sure that we're protecting people within a certain radius of the development. Thanks.
Robert?
Thanks, Chair. If it helps, I think the key thing is recommended condition 13, which basically requires them to erect the development in accordance with the details shown in the original environmental impact assessment. And then you've got the crucial part which says unless the planning authority has given written approval for any such variation in consultation with SEPA. So they don't have carte blanche to change this. They can only change it up to 130 metres from the original location. Which in my view, I think that's reasonable, but members may want to take a different view in that regard. The key thing is that there has to be consultation with SEPA, because if you allow it carte blanche, it's not being sense checked by anyone that's got expertise in those areas. So you're talking about peat, groundwater dependent ecosystem, I think that's right, terrestrial ecosystem, sorry, I forgot that part. And you've also got a general ecology thing there as well, so it doesn't limit us to consultation with SEPA, but it does require it, and that's to give a safeguard so that you're not going to get something that's going to willy-nilly cause environmental damage, because it is important and it does defeat a lot of the council's objectives here. It's just really a judgment call on whether or not an increase over the fairly standard 100 metres micrositing allowance is justifiable in this case. And I think it is. That's my view, and hence the recommendation in the report. Condition 2 that you've got, recommended condition 2, again does require any revised layout to be agreed in writing. So it gives a safeguard. It doesn't give them the green light to go out and do what they want. It requires to be agreed first in writing with us. And if we weren't satisfied with something, whether or not that was due to ourselves or what SEPA were saying, then we basically wouldn't approve that as the discharge of conditions. They would need to come up with something that was acceptable, that satisfied us.
Thanks very much, Robert. You anything to add to that, Mr. Sutty?
Thank you, Chair. Yes, just concur with what Robert said, but it's maybe worth adding as well that it's just to remind members that obviously there is an extant permission, so excavation will be taking place if this development is implemented. Arguably, I think probably the revised condition 13 helps a little bit in as far as we've got to have it with SEPA and got to be agreed in the details. So it certainly it doesn't make the situation any worse than the current extant permission.
Any other, Councillor Hislop?
Chair, might seem a daft question this, but why are we having this item second and not first? Reason I'm asking is, we are removing, or there's a proposal in here for a new layout which would remove turbine 3. And in the previous application, when we had the map up to show where the turbines were, you had turbine 1, turbine 2, and in the middle was turbine 3. Now, we could actually, with an extra 20 metres, be making the previous one look, taking out turbine 3 might make that one look remote from the rest of the development and would have a more significant impact on the Locha, because here you have a single turbine standing by itself, imposing itself. But now we've been told that 3, which if they're all within a wind farm cluster, you wouldn't maybe notice it as much. But we've actually got it now that we might lose turbine 3, which might, because I wasn't sure where Lochar was exactly on the map, but it's within a kilometre of the actual turbine. So if it's at the right angle, it might actually make it look worse. And we didn't have that opportunity to ask that at the previous application.
Maybe I misunderstood, Robert. I thought he said we couldn't consider removing a turbine because that's not in our gift. We're dealing here with an amendment to a previous condition, and that the opportunity to remove a turbine would be another application at a later stage. That's what I thought I understood. So can you help Councillor Hislop, Robert, with that question, please?
Yeah, certainly, Chair. I can give you my view on it. I mean, if you look at the description of the application, it says it's a wind farm comprising 9 turbines. The Section 42 application, I mean, that was an appeal decision that was taken. The Section 42 application is to vary the terms of the conditions. You're effectively cloning that planning permission but changing it in certain areas. I don't think it's achievable. I don't think it's reasonable to impose a condition which is basically removing a wind turbine from a development when the development's described as 9 wind turbines. I think that would be unreasonable. But that's my own view. The thing is, in due course, because they've got the fallback permission, they have that permission already for 9 wind turbines, so I think it would be very difficult to kind of justify the removal of one of them. If they want to do that in due course, then they can do that in their discharge of planning conditions application after the event. If that's what they want and we agree to it and that's what they want to implement, then fine. But I don't think we can actually take it away from their planning permission by means of a condition. I think that would be unreasonable. But you maybe want to get a legal opinion on that too, Chair.
Thanks very much, Robert. And I'll ask Mr. Sutty to come in and I'll come back.
Chair, I'm not looking to take it away, but this application seeks consent for a different layout plan and infrastructure position beyond that which is possible under terms at the present condition 13 to appeal PPA 170, etc., and the proposed deletion of a single wind turbine. That's what this application is. It's a proposed deletion of a single wind turbine, according to 1.12 on page 64. But I'm maybe reading that out of context, and I don't know what that means.
Mr. Sutty will help.
I'm not sure if I can help for the bigger question, but it was just to answer your initial question in terms of why did this one come first. Where you get a number of applications for the same site, what we normally do on a committee agenda is put them on in chronological order. So if you notice, item 4 is got the reference number 539, and item 5 is reference number 647, so it came in later. I do sympathise with members. I'm in the same boat. I get confused as to quite what the difference is between all of them. There's so many different applications have come in for FEL. It is quite a complicated system. But that's purely the reason why they come in this agenda order. You've obviously got to look at each one on its own merits, and you might find one acceptable and one not.
So, I don't know if that's helpful or no. Laura, you want to give us some legal advice, please? Because I don't see in the recommendations where it says remove a turbine.
Chair, but it says under 112 that this is here because of a new layout, which will mean the deletion of turbine 3. Now, maybe I'm reading that wrong, but with that removed, it then makes turbine 1 and the previous one stick out further, and you might not have actually, you know, at that point we might have looked at it differently. But you can't, like you say, you look at each one individually, so just wondering, you know, what would this have had an impact on the previous one if this had come first?
Laura, please.
Thanks, Chair. Through yourself, if it helps, the deletion of the single wind turbine that you've pointed out is in relation to item 5. And in item 5, they're not looking to increase the height of turbine 1. The increase of height is in item 4, which doesn't have anything about, in the report, doesn't mention anything about deletion of a turbine. That said, the granting of planning permission does not make someone duty-bound to build out all of them. But the deletion appears in item 5, which maintains the height of 180 metres.
Councillor Hislop, did you want to come back in?
Chair, but we've already agreed that it's going to 200 metres on the grounds that that was the layout which was showing up on the screen, 1, 3 and 2. Now we've got 3 missing, so 1 sticks out by itself, and the view was that because it was part of a group that 200 wouldn't make that much difference, but being stood alone, you know, if you're looking at it at one angle, it would look, you know, why have you got this great big single turbine standing by itself?
Well, we can revisit agenda item 4 because we've addressed that. So we're at questions for the case officers. If you have a particular view when they come to determination, I'm sure we'll deal with that at the time. So we have questions for the case officer. I don't see any further questions, so we'll go to representations. We have one representation for Trevor Proctor on behalf of Help Save Morecambe Fell Group. An objector, statement read out by the clerk, and 5 minutes again, Tracy, because it's a major application.
Thanks, Chair. This statement replicates the one I read out for item 4, but obviously it's a separate application, so I'll read it out again. We strongly object on behalf of the 196 members of the Help Save Morecambe Fell Group. Consent for the Fell Wind Farm was based on details specified by Energy Contour as their optimal design. No further changes should be allowed. Energy Contour have submitted 5 incremental Section 42 applications, where a completely new application should have been required. Turbine 1 is closest to Loch R. Increasing turbine 1 from 180 metres to 200 metres high has the most negative visual impact on this valuable tourist attraction, making turbine 1 even more overpowering and out of scale. Moving the positions of 4 turbines place these turbines closer to hill summits at higher AODs, making any previous permission invalid, as the viewpoints and visibility are all negatively affected. Condition 13 states clearly that consent is based on the infrastructure being sited exactly as shown on the site layout. SEPA object due to the excavated peat for turbine 5, peat storage and the use of peat deposited for bunds and covering burrow pit excavation. GWDTEs could have significantly affected by micrositing changes. These have not been investigated, and as protected species these should lead to an automatic refusal. For the adjacent Gackrow wind farm, the CLA stated the Fell turbines will be 200 metres. In my opinion, the scale of the Fell turbines is regrettable in terms of achieving a good fit with a foothills LCTs for 18 and 18A landscape, and also the impacts of aviation lighting in an interestingly dark area. Energy Contour have submitted a further Section 42 application to increase all turbines from 200 metres to 220 metres. Please stop them from gaming the planning system yet again using multiple incremental Section 42 applications to achieve the exceed their original refuse scheme. If this was a new application for 8 turbines of 220 metres against a baseline of 0 turbines, would it be approved? Please refuse all these incremental Section 42 applications. Thanks, Chair.
Thanks very much, Tracy. And given that's a statement, we're now in session. And I have to say, we've got this public document pack, and Councillor Elizabeth already referred to it, which clearly says fell wind farm site between Black Creek Wind Farm and Lochar, 7 kilometres to the southwest of Money Hive, application for erection and 35 for operation, a wind farm comprising 9 turbines. Now that's what this document says, and yet Councillor Islip has brought our attention to 112 where it talks about the deletion of a single turbine. It's contradictory, so I would be looking for advice from either Mr Sutty or our legal officer, Laura Whitelaw, on exactly what being asked here and what we can and cannot do, because we cannot accept an application for 9 turbines, then halfway through the report read that he's wanting or they want to have it reduced to 8. I note that Councillor Driver is wishing to speak, but I'll wait until we get some advice from our legal team or from Mr Sutty's head of planning, because we can't have contradictory statements in a single report. I know it's Councillor Campbell wants to speak as well, so I've got Councillor Hislop, who had raised up his hand, then Councillor Dryborough, and then Councillor Campbell. Once we've heard from our legal team and our planning officer or senior planner, or planning and development manager, whatever your fancy title is, David. Whilst our legal officer or legal team studying this, I'll just hear from Councillor Dryborough, Councillor Hislop and Councillor Campbell. So, Councillor Hislop, you want to come back in again?
Chair, it might sound funny this, but I have no problem with the change in the conditions they're asking for, which is the micrositing, but I just have concerns about, you know, the process we've been through today, whereby we've possibly taken the turbine out at their request, but we're not conditioning it, and how it affected the previous application, and did we take that into consideration when we looked at the previous application? But the conditions for this one, I think, safeguard the issues with regard to the peat, whereby SEPA will look at that one. Another one says that we will come back and have a look at the turbines, the 9, or is it 8, I don't know, and that seems to be the issue. But those two don't worry me. It was just the process that we went through today to get to where we are.
You got what I hope was helpful advice from Mr Sutton, how that happened. Councillor Dryborough, please.
Yeah, thanks, Chair. I think we've got to look at the reports in front of us rather as thing, and I'm sure I heard Robert Duncan say earlier on that if they were to try and reduce the number, another planning application would have to come in to the planning application or the planning department, and that would give me some confidence that, you know, that would happen. So therefore I would agree with the recommendations in the report, and if there needs to be a motion for that, I'm fine.
Thanks very much for that, Councillor Driver. That's helpful. The worry I have is that if we agree the report is set out before us, it says he seeks to reduce the turbine height to 8. So I'm concerned that by agreeing the report, we're actually agreeing that the turbine could remove. And I'm just looking for legal advice.
So just to clarify that then, Chair, perhaps another recommendation that if there was to be a further an application, or they were trying to reduce the number of wind turbines on the plant, then a further application would have to come back into the planning department.
That might be a useful thing. I'll ask Mr Sutton and I'll go to Councillor Campbell.
Thanks, Chair. As Laura just said before, there is no obligation on a developer to implement every single turbine that they get permission for. For example, the first wind farm I dealt with was Minska, which was approved at 17 turbines, but they chose to only implement 16. So that you cannot force a developer to do all of it. If you've got a materially different layout for 8 turbines, then that would definitely require a new planning application. Beyond that, I mean, all I can say is you've got the what you saw on the screen, what the chair read out at the start is the description of the development. You've got the conditions in the supplementary pack before you. That's really the decision that's being recommended today. I don't know if you wish to go to Laura now, Chair.
Well, I do, but I might as well have Councillor Campbell in case there's another question that Laura might be presented with. So I'll have Councillor Campbell first, then I'll go to our legal team.
Thanks, Chair. Yeah, it is a bit confusing. However, I was looking at 4.7 on page 74, and it says in relation to what is sought, members should note that whilst a section 42 application may only consider the issue of conditions to be attached, and if you read that whole paragraph, what the applicant is wanting and what we are actually recommending, I think this is where the confusion is. Now, we're recommending that they remain with the 9 turbines. As far as I'm concerned, what Robert and David and others have said. So I would go with the recommendations and second Councillor Dryburgh if he wishes to put that as a motion.
That's very kind, that's helpful. So we'll hear from Laura and then we'll go to our decision. Laura, please.
Thank you, Chair. Through yourself, rather than raising a question, Councillor Campbell actually has answered the question as I was going to do it there and direct you to paragraph 4.7, which is the point that Robert had made during his submission. It was also to reiterate that in the application to increase the height, it doesn't have the same requests for changes as you have here. So the permission that allows them to increase the height of turbine 1 back to 200 metres is requesting different changes from this one. So if they go to implement this permission, they would not have the ability to make it the 200. Looking to David in case what I'm saying is incorrect on a planning basis, but that is my understanding, that if they chose to go with the changes that this permission gives them, this permission does not allow them to increase the height to 200 metres.
If ever water was muddied, I think that just happened.
Chair, does
Councillor
that mean
Hesmond.
to say if they implement the other one first, build turbine 1 out, and then go for this one with a revised layout for the rest of them, they can do that?
They would have to come back to us with a revised plan application. Mr. Sutty?
Yes, Chair, you can't mix and match your permissions. I mean, this is exceptionally unusual to have quite so many Section 42 applications for the same site and the same development. And it clearly is muddying the water in members' minds and probably my own as well. But yeah, you can't choose part of one and part of another. You would have to implement all of one permission that was granted or not.
So on that basis, Councillor Drysdale.
Thanks very much. We talk about mudding the waters. That's why the community is completely confused as well. And Energy Contour keep doing this time and time again to our community. So, David, it's an interesting point that you made. And I just wondered, do we as a council have any policies on how many Section 42s we are willing to take? Is there Scottish legislation on that or not? Do we just have to keep taking them time and time again? Thanks, Chair.
Yeah, and David will answer, but I'm certain the answer is no. We can't limit.
Thank you, Chair. Yes, Robert actually alluded to this earlier, that we do not have the power to decline an application that is competent. If it comes in and it's a valid application, we have to accept it and determine it. The only power that we have is under Section 39 of the Act, where if you get exactly the same application time and time again, you can refuse to entertain it. But that's not the case here, because they're clearly wanting something slightly different to the previous application you looked at.
So we have a proposal and a seconder to go with the officer's recommendation. Councillor Drysdale.
So, thanks, Chair. With regards to all the discussions we've had today, we're all in a very difficult, well, I'm certainly put in a really difficult situation here. It is my community. We represent the whole of Dumfries and Galloway. I don't know how I can go forward in this, because I don't think I'll get the support in the room, and I understand why, because it's very complicated. But if I wish to just record my dissent, does that mean I have to present some sort of reason without a motion? Because I really don't want to keep approving these Section 42s, pardon me, time and time again on the same sites, because I do think it's mudding the waters, confusing people and potentially creating environmental damage to the peatland in and around where we all live. So I don't know how I go about that legally. Perhaps I need to go through Laura. I just wish to record dissent, that's all. And if I was questioned on it, it's for all the reasons that I've mentioned before, as well as all the material conditions that I've also mentioned, the effects on wildlife and the release of stored carbon and peatland, effect on peatland, etc. Thanks, Chair. I take guidance from
I'll
yourself.
ask Laura, but I know you can't record your dissent unless you put forward a proposal, a motion, and it's no seconded. However, if you agree with this particular application, it restricts the height of the turbines to 180 metres, so it might be in your interest to leave this one alone. But I'll ask Laura for Tracy even for advice.
Thanks, Chair. Yeah, so as per our standing orders, the mover of a motion or amendment which is not seconded may have their dissent recorded in the minutes. So you should really give a reason as to why you're recording your dissent. So if you want me to minute that, I would need grounds that you're putting forward as a motion.
Thanks, Tracy. That's helpful. No, I don't think I'm able to do that because my motion's just based on the initial application, and as the Chair said, it's still 180 metres, so I do have difficulty with it. But so I'll just leave it at that. But thanks, Tracy. Thanks, Chair.
Thanks for that, Councillor Dreiser. So a motion and an amendment to go with our recommendation. If there are no alternative proposals, can you confirm the decision of the committee, please, Tracy?
Thanks, Chair. Members have approved the application subject to the conditions that were circulated in the supplement pack on the 23rd of September, which was sent to members and is available online. Thank you.
Thank you very much, Tracy. Move on to agenda item 6. This application was withdrawn. Persons notified by email on Tuesday, 23rd of September at 8:25 a.m. So we will not determine agenda item 6 today. It's been withdrawn by the applicant or the applicant's agent. Move on to agenda item number 7. An application for the change of use of dwelling house, class 9, to form residential care home, class 8, at Corbridge House, Milton, Crocketford. This is a full application, reference number 25/0864/full. Recommendations to approve subject conditions, and the case officer is Chris McTeer. Chris, will you take us through your presentation, please?
Thank you very much, Chair, and good afternoon, members. This application is in front of you today as there's been 6 or more separate individual third-party objections received to the application. Just by way of a verbal update, the report in section 3 lists 41 objections. There are actually 42 objections. There was a mix-up between a farm and a farm cottage address, but we have received 42 third-party objections to that one, and I'm grateful to planning admin and committee admin for making sure that everybody who submitted a timeless objection to this application has been notified of the procedure for its determination today. So the application site, as you can see, is known as Corbridge House, and it's located on the edge of Milton, which is an identified small building group, 10.4 kilometres northeast of Castle Douglas. You can see there the footprint of the house as it stands. The proposal is for the change of use to form a residential care home under Class 8, and also the erection of a 1.8 metre high close boarded fence along the western boundary to the site there. So just turning to a few pictures of the house itself, you can see it's relatively modern, probably less than 20 years old, fairly large, 6-bedroom property. So this is the site entrance from the old military road, which I think is the C1S public road, and you can see it's agricultural land located to the east and north of the house. This is the space in between the two properties occupying the site. So the house next door is Albinach, and you can see the space in between there. Changes are mostly confined to the internal aspects of the house, so there are requirements for smoke alarm sprinklers, updates to electrics and things, but nothing that would fall within sort of the remit of planning. That would be my colleagues in building standards who would take care of that. The proposed first floor layout, again, some minor changes to that, and including boxing in the top of the stairs where there's currently a banister. So an assessment of the application as it stands has highlighted the noted key issues there. So the first thing to note is the principal use of the dwelling still remains as residential. There is also the proposal would assist with an identified need for dwellings of this type. That's set out in paragraph 4.6 of the committee report. Again, as noted, there are no external alterations to the dwelling. There are some additional security lighting or security lights proposed over and above those that are already on site, but no planning permission is required for those. The fence, which also forms part of the application, only really requires planning permission forward of the building line. The rest of the fence is permitted development under householder PD rights. As part of the application, the Council Roads Officer was consulted and offered no objections, subject to a condition requiring the implementation of the required parking, which meets the current standards of the National Roads Development Guide. Also note, again, there was 42 third-party objections received to the application. They are set out in section 3 of the report, and a summary of the material points raised is at 3.2. There's also a note of the non-material points underneath the list of material ones as well. The recommendation is to approve subject to conditions, and I'm happy to answer any questions that members might have.
Thank you very much, Chris. We're in questions for our case officer. Councillor Maureen Johnson, please.
Thank you, Chair. I would just like to mention the parking here that's in this here, and that parking is provided for 6 vehicles, but then goes on to say on page 124, 2.2, that this is just really a prediction on which is an unknown factor, and also anticipated. Again, expected. Well, how many? There would be caterers, medical staff, cleaners, visitors, so it is an unknown number. So how many vehicles are predicted or anticipated? And I have a second point too. Thank you, Chair.
Okay, we'll get them one at a time if you want, Councillor.
Sorry?
Do you want to do them both at the time, or do you want a response to that one first?
I'll have a response first and then I'll go to the second point.
Chris, please.
Thank you.
I suppose the Council Roads Officer response is based on the known information that is sort of set out in the National Roads Development Guide. So they look for the number of bedrooms, the number of staff. So that's a known quantity. We don't know how many visits there would be by, say, medical staff or social workers. Those things, I imagine, as an operational sort of matter would occur as and when, but at the moment the Council Roads Officer is happy with the level of parking. It can be accommodated within the curtilage of the house.
Councillor Johnson, you want to come back?
Yes, thank you. Again, it's just an unknown quantity. My second point, the old military roads is a C-class road and in a rural area. Now, during severe adverse weather conditions, mainly winter, C-class roads are not seen as a priority when it comes to gritting or clearing of snow. Anyone living in a rural area knows how quickly the weather-related incidents can cut people off. And if this residence is given change of use to house vulnerable young people, will this be taken into consideration that old military road C-class be given priority status during the adverse weather conditions? Thank you.
Thanks, Councillor Johnson. That's not a planning matter, I don't think, but I'll just clarify it with Chris.
It's not something I can answer, I'm afraid, sorry.
Thank you. It's just
Thanks,
a point I
Councillor.
wanted also to raise as well. Thank you.
Thanks, Councillor Johnson. Councillor Emma Jordan, please.
Thank you very much, Chair. I just wanted to ask for clarification, if I may, please, from Chris. He said that properties of this type was he mentioned that as a bonus, as a plus for having this. Could you just clarify what you mean by properties of this type, please?
Chris?
Sorry, could you perhaps rephrase that? I'm not quite sure. Is it
Apologies.
as in
Yeah,
a dwelling
apologies.
house or as a residential
So you,
home?
in the bullet points that you showed on your presentation, you said that properties of this type were needed, that we needed to increase properties of this type. I'm sorry, I'm not wording it very well. I do apologise for that, but hopefully you understand what I'm asking now.
Yes, so I did say that properties of this type, so development of this type, I'm saying would assist with an identified need for dwellings of this type. So that's set out in paragraph 4.6, which I sort of took from, now I know there will be members probably that also sit on the Council Social Work Services Committee as well. So if you have a look about sort of 2/3 of the way through, paragraph 4.6, the report says it notes that residential placement numbers have continued to increase over the last 2 years. So this was, again, this was taken from the Head of Social Works sort of committee report in April this year. So really it was, yeah, it's to, yeah, just as I say, there's support for this type of dwelling within wider council policy. I mean, we are one council, so it's probably helpful to mention that as part of the planning process.
Thanks very much, Chris. You want to come back in, Councillor Johnson?
Yeah,
Jordan?
yes, please. Yes, please. Thank you, Chair. That's what I thought you meant. Thank you, Chris. I just wanted clarification on that. Thank you very much.
Thanks very much, Councillor Jordan. If there are no other questions for our case officer, we'll go to the representatives today. So we have quite a number. They've been taken in the order, I believe, that requests to address the committee or submit objections or statements were received. So the first person today is Richard Barber, an objector in person. So if Richard would like to come forward, please just take a seat somewhere, Richard. And there is a process that we trust, given the number of objections that you will adhere to. You'll have 3 minutes to make a representation to the committee. I will remind you with 30 seconds to go to bring your presentation to a conclusion. And if you've been kind enough to wait in case members have questions for you, I'd be grateful. So whenever you're ready, sir.
Good afternoon. My name is Richard Barber, and we farm the land directly behind the proposed care home and have a farmsteading and farmhouse within 100 metres of the proposed care facility. I want to stress that I understand the importance of supporting young people, but this location is not suitable. My main concerns are threefold. Firstly, road safety. We, as other farmers do, use heavy machinery daily on narrow country lanes. Adding staff cars, visitors and potentially residents will increase the risk of accidents, particularly in blind corners, which has already seen one fatality in the past 3 months. Secondly, the welfare of our animals. Our farmsteading boundaries are secure for animals, but they're not secure for intrusive persons. There is a genuine risk from this type of facility for the risk of trespass, disturbance, or even vandalism, which could harm livestock and threaten our livelihood. There is neither room within the garden of the proposed facility or other recreational facilities within Milton to satisfy the needs of young people who need outdoor space to thrive. This will undoubtedly lead to their safety and the safety of our animals and our staff being compromised. A care facility of this kind requires a secure and safe environment, but an active working farm beside it raises obvious risks for both the young people and the local community. Finally, I would like to add that I also have serious concerns about the safety of the local children of Milton, who will undoubtedly come across the children from the care facility. Amongst numerous behavioural issues, ACAD's website states that these young people, aged 8 to 18 years, may also have, and I quote, problematic sexualised behaviour. I fear for not only my own teenage daughters, but other children in the village and the surrounding area too, who will lose their right to freedom and safety. In my opinion, this is not for the well-being of local troubled children. This is about a company who has a registered office based in Dubai, increasing the return on investment by buying a property at cheap, rural Dumfries and Galloway property prices, rather than investing in an area more suited. I urge the committee to consider whether this is the right location for such a facility. Thank you.
Thanks very much, sir. Any questions for Mr. Barber? Thank you for coming forward, sir.
Thank you.
We now have the first of two statements that our clerk Tracy will read out.
Thanks, Chair. This statement is from Sarah Barber, Objector. Approximately 40 residents in Milton currently enjoy a safe and peaceful rural environment in line with the protections of Article 8 of the Human Rights Act. The proposed change of use to a care facility would fundamentally alter the character of the village and erode the security and well-being of its residents. As a parent of two teenage daughters who use the school bus stop daily and regularly run and walk in the village, I am particularly concerned about the impact on child safety and freedom of movement. ACAD's own website confirms that the facility would house children aged 12 to 18, but also states that when capacity allows, it may accommodate young adults up to the age of 24. My children and the other children within the village would no longer feel safe to use the bus stop alone and enjoy the freedoms they have for years. The proposal fails to safeguard the residential amenity of existing households, whether that's younger or older residents. The introduction of such an institution would place a disproportionate burden on local infrastructure, undermine community cohesion and diminish the rights of families already living here. For these reasons, I respectfully urge that the change of use be refused. The next statement is Alan Broach, Objector. This statement challenges the claim that the proposed Class 8 children's care home at Corbridge House is comparable with a large family dwelling house, Class 9. While both are residential uses, the operational, functional and regulatory differences are significant and material to planning. The key differences from a family home: family stability versus institutional rotational. A family home is a single, stable household where members are related and share long-term bonds. By contrast, the proposed care home will have frequent changes of residents and rotating staff, creating a transient environment rather than a cohesive family unit. Staffing and operations. The care home will operate within a 1-to-1 staffing ratio, a full-time manager and multiple staff on shifts, present 24/7. This introduces an institutional character far removed from a domestic household. Regulatory and professional footfall. Unlike a family home, the care home will be subject to care inspectorate regulation, structural routines and controlled access. It will also attract regular visits from social work, therapists and health professionals, creating a level of activity far beyond that of a typical family home. The impact on the character and amenity. The combined presence of residents, rotating staff and professional visitors significantly increases occupancy, traffic and noise compared to a single household. Shift changes and scheduled visits introduce activity at times and frequencies typical of a family home. Lived experience of antisocial behaviour. Local communities across Scotland have reported issues with similar facilities, including absconding, police call-outs and disruptive behaviour. These concerns are echoed in the committee report's summary of objections, which highlight fears of antisocial behaviour and community safety risks. These are not speculative, they reflect real experiences and are evidenced via lived experiences from Milton residents that have lived beside such a facility and ex-police officers that have attended antisocial episodes in such facilities. Policy context. Policy OP1 requires compatibility with local character and amenity. While H6 supports particular needs housing, it does not override the need to assess whether the use introduces a materially different character. Comparing this proposal to a family home is misleading and underestimates its impact. In conclusion, the proposal is not comparable to a large family dwelling. It is a specialist institutional use with distinct operational and regulatory characteristics, and its impacts must be assessed on that basis. Mr. Chair.
Thank you, Tracy. That's two statements, members, to take account of. The next person to address the committee is Derek Douglas. Derek, if you'd like to come forward, please. I'm sure you'll have grasped the process. It's 3 minutes. I'll remind you with 30 seconds to go, and if you'd wait, just in case anyone's questions, I'd be grateful. Whenever you're ready, sir.
Good afternoon. My name is Derek Douglas, a resident of Milton. In Mr McTeer's report, he claims that antisocial behaviour and other criminal activities are not material to the consideration of his planning application. It's my understanding that antisocial behaviour and the fear of crime are recognised as valid material planning considerations under UK planning case law, as long as they're objectively justified based on reasonable evidence and directly relates to the proposed use of the site in question and not the general area. Myself and my wife are both retired police officers for over 60 years between us, and we've attended numerous incidents of antisocial behaviour and other types of disturbing behaviour within, like the Gifford House, Ladyacre, Merton Hall and Closeburn. Nothing's changed since we've retired. I've reached out to serving police officers and they are still continually attending these types of homes on a regular basis. I've brought to Mr McTeer a couple of months ago now about a planning department document in which he proposed a children's residential care home was explicitly identified as a bad neighbour. In section 4 of his report, he's completely dismissed our legitimate concerns and his own department's prior recognition of the bad neighbour designation, choosing to align himself with ACAD's narrative that the change of use would not raise any issues that would have a detrimental impact on the amenities of nearby neighbours. Planning policy must be applied with consistency and transparency. Selective interpretation, especially when it favours applicants who present demonstrable misleading documentation, undermines public trust in the planning process. ACAD's submission contains factual inaccuracies and omissions. If the true behavioural patterns and operational realities of our facilities were disclosed, it's highly unlikely that this application would meet approval. Respectfully request that this committee seek direct clarification from Mr McTeer regarding why his department's bad neighbour designation has been disregarded, what evidence was used to justify his claim that there would be no detrimental impact on neighbouring amenities, and why ACAD's assertions have been accepted without rigorous scrutiny, or indeed any scrutiny, especially in light of contradictory evidence and community testimony. This matter goes way beyond a single application. It speaks to the integrity of the planning process itself. The community deserves answers, and this committee must ensure that this policy is not only followed, but enforced with fairness and accountability. I have a picture here I took from Facebook.
You have 30 seconds to go.
Okay, I took this post from Facebook. This is 1 Mill Bank, Lockerbie, a property owned by Caretech. You'll see there's a number of emergency vehicles outside there. There's a post attributed to it, and what it says is, and I'll cut to the chase, the coppers parked there, they're always at them flats. So this demonstrates what's coming to Milton if this application is approved. Thank you.
Thanks very much for your presentation, sir. Have anyone any questions for Councillor Hislop for Mr Douglas, please?
Mr Douglas, the piece of paper you held up, what is the tenure of their, are they the same age children that are meant to be in mill flats as are proposed for here?
The actual mill bank, that's actually used as supporting evidence in this application. I think it is to do with children up to the age of 18. What age they are, I do not know.
Thanks, Councillor Hislop. Any other members have any questions? In that case, thank you for coming forward, sir. We now have a statement from our clerk.
Thanks, Chair. This statement is from Anna Keeley, objector. Having previously lived near a care home, I would like it noted that this caused distress and antisocial behaviour for the local residents. The police and ambulances were there frequently at the home on average twice a week. There were drug overdoses and a suicide attempt which required responders to attend the scene in the early hours of the morning, depriving residents of their sleep due to the commotion. Sometimes residents were forcibly removed by the police, which was distressing for the neighbourhood. My car was damaged and the windscreen cracked, and the perpetrators were seen going into the care home. I was frequently the subject of verbal abuse from one of the young people living in the care home. Its residents were constantly knocking on my door at all hours of the day and night, and often sat on the curbs in front of people's houses screaming at unsociable times, usually 2 AM to 5 AM. I had difficulty selling my house at the valuation price due to the behaviour of the residents at the care home. Parking was a nightmare. My drive was blocked on several occasions due to the numerous meetings that took place there. There was the manager's car, the social workers' cars, the 3 to 4 staff cars, and the parents and sometimes police cars. Some days there would be 8 cars. My objections are based on the fact that there will inevitably be antisocial behaviour, and I do feel that this will be more so than that of a normal family, as the residents are indeed not part of a normal family. As a teacher, I am perfectly aware of how young people behave when they cannot regulate their behaviour, having seen students destroy school property when they cannot control their emotions. The police force is somewhat depleted in Dumfries and Galloway, more so than the densely populated area where I used to live. I feel that there is not the infrastructure for first responders to support and deal with incidents which will occur at this facility swiftly, causing the residents to become more distraught and heightened emotions which may result in a child not getting the right care quickly enough. The village of Milton has a lot of older residents which will find the care home difficult to adjust to, causing distress to the local residents and impacting on their mental health. Whilst I accept that children need to be nurtured, cared for, I feel the location is not right for this facility. There is absolutely nothing for the youngsters to do. There are no shops, no play parks, and hardly any young residents for the care children to interact with to allow them to gain a positive experience. I am concerned that it will have an impact on the house prices which are near. Finally, when the previous care home near my old house was commissioned, we were also promised that it would not impact the neighbourhood with antisocial behaviour residents. This turned out to be a complete fabrication of the truth due to verbal abusive teenagers. So, Chair, thanks.
Thank you, Tracy. That's another representation to take account of members. The next speaker is Melissa Kerr. If Melissa would like to come forward, please. Same arrangement, Melissa, please, 3 minutes. I'll remind you 30 seconds to go.
Okay.
And if you'd remain in case of questions for you, and again, whenever you're ready.
Sure. I'm Melissa. I'm here to highlight the serious safety concerns for the children in the village and request this application is turned down. This was missed out of the summary of report of objections, and I don't understand why. It impinges on the basic human right of all children to feel safe and protected from harm. The village is small and there's rarely anyone around to help or to act as a deterrent for behaviour issues or risky situations. We know the home residents will be ages 6 to 12, but can also be teenagers and young adults. We are told they can have challenging behaviour, verbal and physical aggression and sexualised behaviour. The village children are therefore vulnerable, being in a secluded rural setting with no help at hand, no eyes or ears that would be around in a more built-up area. School-aged children walk past Corbridge House alone and access school transport near Corbridge House, where there are no other houses in the immediate vicinity that overlook. It is unacceptable, therefore, this risk of aggression or sexualised behaviour whilst alone in a secluded location for our children. We know that, unfortunately, incidences happen at these homes. The opportunity for harm will be high. I have compassion for the children needing these homes, and no supportive housing is needed, but these risks clearly need to be considered when choosing a location. I would add that the only family with school-aged children living in the main body of the village moved out because of the dangerous road and the children being so limited in where they could play. So the location is not suited for the care home children themselves. In conclusion, it is clear that those applying for this home have not properly assessed risk for the children of the village. I feel this home will create too many opportunities for intimidation or serious harm, and this level of risk is unacceptable for our children. Thank you.
Thanks very much, Melissa. Anyone have any questions for Melissa? In that case, thank you for coming forward.
Thank you.
Now have 4 statements from objectors that Tracy will read out, just whenever you're ready, Tracy.
Thanks, Chair. This statement is Ian Lumsden, objector. I refer to the planning report submitted by Chris McTeer and wish to raise the following points of concern from his report, which I feel he has failed to address adequately. 1. Conflict with LDP2 policy H6 and MPF4 policy 16C. The proposal fails to demonstrate that it will meet locally generated demand or that the need of the local client group as required by policy H6. No planning obligation or condition secures local placements, and evidence shows existing ACAD homes in the region predominantly serve non-local children. The proposal therefore does not address an identified local provision gap under MPF4 policy 16C. 2. Unsustainable and unsafe access contrary to LDP2 policy T2 and MPF4 policy 13. The site lacks pavement, street lighting and reliable public transport. The transport assessment omits predictable visitor trips, resulting in underestimation of traffic and parking demand. The proposal would be car dependent and fails to demonstrate safe and sustainable access. 3. In respect to insufficient on-site parking and highway safety concerns OP1 and T2, there is an internal inconsistency between the claim that parking is sufficient for all staff and drawings showing only 6 spaces, despite a one-to-one staffing model and visitor demand. This fails to demonstrate adequate parking and safe manoeuvring contrary to OP1 and T2. It would seem that Roads Department have failed to take full cognizance of all of the relevant information. 4. Harm to local character and amenity OP1 and OP2. The proposed 1.8 metre close-boarded fence forward of the building line, combined with additional lighting, would erode the rural character and adversely affect amenity. These impacts would not have adequately been assessed, contrary to OP1 and OP2. 5. Bad neighbour impact. The Council has previously acknowledged that residential care homes can constitute a bad neighbour use, unlike urban examples where such uses replaced more intensive uses. This proposal introduces an institutional use into a tranquil rural hamlet, creating disproportionate amenity and character impacts. 6. Caretech's practice of buying rural properties in Dumfries and Galloway and then busing in children from outside the region creates disproportionate ratio of children with complex behaviour needs per head of population in a small rural communities. This is not conjecture. Community evidence shows most ACAD placements are non-local. This clustering effect undermines the policy intent of H6 and MPF4, which seek integration and community cohesion. Instead, it risks social imbalance, strains local services and introduces challenges that are not proportionate to the scale and character of Milton. Far from benefiting the region, this model exports problems into rural hamlets without delivering the claimed local welfare gains.
That's 3 minutes.
Thanks, Chair.
Thank you.
Finish that one. Thank you.
And just to be fair, we allow the same 3 minutes for any written representations that we do for verbal ones.
Chair. The next one is Claire Mitchell, objector. I wish to formally object to a proposed change of use at Cambridge House from residential dwelling to an ACAD children's residential care home under the management of Caretech. While the need for appropriate care provision is understood, this site is wholly unsuitable and the application conflicts with both Dumfries and Galloway Local Development Plan 2 and wider Scottish Planning Policy SPP. 1. Loss of residential character, policy OP1 SPP placemaking. Cambridge House lies within a quiet rural residential setting. Its conversion into a managed institutional facility would undermine the character and identity of the area. LTP2 Policy OP1 requires development to respect the character of the surrounding area and to be compatible with existing uses. SPP paragraph 14 and 40 stresses the importance of placemaking and protecting the distinctiveness of character and places. This proposal does neither. 2. Impact on local community amenity Policy OP1 SPP community cohesion. The surrounding population is largely older and values the tranquility of this location. The operation of the care facility with staff shift changes, service deliveries and visitor traffic will introduce noise, disturbance and disruption. LDP2 Policy OP1 requires protection of community amenity. SPP paragraphs 15 and 29 emphasises development that promotes safe, pleasant and welcoming communities. This application is not compatible with the settled residential environment. 3. Lack of amenities for young people Policy OP2 SPP sustainable communities. The site is remote from schools, leisure facilities, youth services and public transport. It offers no realistic opportunities for integration or access to community life. LDP2 Policy OP2 requires development to contribute to inclusive and sustainable communities with access to essential services. SPP paragraphs 28 and 77 states developments should reduce social isolation and support access to community facilities. Placing vulnerable young people in this isolated location would run counter to these claims. 4. Highway and pedestrian safety Policy T2 SPP safe access and transport. Corbridge House fronts the C1 road, now used as the main diversionary route for A75 traffic and regularly accessed by large farm machinery. The road has no pavements, no street lighting and limited visibility. Staff vehicles, deliveries and visitors will add to traffic movement, significantly increasing risk.
30 seconds.
LDP2 Policy T2 requires development to ensure safe access for all users. SPP paragraphs 273 to 275 reinforces the requirement for safe, well-designed access and transport infrastructure. This proposal fails on both accounts. 5. Unsuitability of location of specialist facilities Policy OP1, OP2, SPP substantial and well-being. Specialist care homes require safe, sustainable and well-serviced locations and this site provides none of these. Thanks, Chair. The next statement is Nicholas Mitchell. There are 5 key reasons this development does not meet the local development plan. 1. Loss of residential character OP1. Corbridge House lies within a quiet rural residential area. Its conversion into an institutional facility would undermine the established character and setting, contrary to Policy OP1, which requires all development to respect the character of the surrounding area and avoid adverse impacts on local amenity. 2. Impact on local community amenity OP1. The surrounding community is home to many older residents who value the peace and stability of the area. A managed facility with shift changes, visitors and service traffic would bring disturbance and disruption. Policy OP1 states development must be compatible with surrounding uses and must not adversely affect existing community amenity. This proposal fails that test. 3. Lack of amenities for young people Policy OP2. The location is remote and isolated with no schools, leisure facilities or community services within walking distance. Policy OP2 requires development to support inclusive and sustainable communities with good access to services. Placing vulnerable people here would compound their isolation rather than help integrate them into community life. 4. Highway and pedestrian safety Policy T2. Corbridge House fronts directly on the C1 road, which now serves as the main diversionary route for A75 traffic, which is heavily used by large farm machinery. The speed limit is 60 miles per hour and there is a blind bend approximately 30 metres from the drive entrance. The road has no pavements, no street lighting and restricted visibility. Staff vehicles, service deliveries and visitors will increase traffic movements, creating serious safety risks. Policy T2 requires that development not compromise road or pedestrian safety. This proposal clearly does. 5. Unsuitability of location for a specialised facility Policies OP1 and OP2. Specialist children's homes require safe, sustainable locations with access to appropriate infrastructure and community services. This isolated rural site does not provide these essential conditions, and this proposal is therefore inconsistent with the LDP's overarching aims of sustainable development and community well-being. The proposed change of use is contrary to the key policies of the local development plan, specifically Policy OP1, failure to respect local character and amenity, Policy OP2, failure to support inclusive and sustainable communities, Policy T2, failure to ensure safe access and transport infrastructure. The development would erode the area's residential character, harm community well-being, place children in an unsuitable and isolated environment, and create an
30
unacceptable
seconds.
road and pedestrian safety risk. For the reasons, I respectfully urge the committee to refuse the application. The following list summarises the key grounds for refusal and associated policies. Loss of residential character, rural setting would be altered by institutional use. Contrary to LDP2, Policy OP1, development must respect local character and be compatible with surrounding uses. Contrary to SPP placemaking, paragraph 40. Impact on local community amenity. That's
3 minutes.
3 minutes, Chair. The next statement is Peter Morris, objector. Apologies for not being able to attend the meeting and speak in person. I note the Planning Application Committee report recommends approval of the proposed planning application. I also note that whilst listing some objections from the local community A to P and accepting that these are valid planning matters and are of some weight, several of the objections have been similarly rejected and the remainder not properly considered. More specifically, the report states at 4.5 that proposals must meet locally generated demand and the needs of local client groups and should be integrated into the local community with access to local services and facilities. Nothing has been said to explain how this proposal meets these criteria. Milton has no demand, nor has it any services and facilities, so the meaning of local obviously does not mean local to Milton. In that case, why should Milton be the location for a care home that supports the needs of non-local communities? Also at 4.6, the statement is made that it is council policy to ensure fewer children and young people in care are placed out of the authority. And at 4.7, the statement is made the provision of local residential institutions is an important part of the wider aim of community building for all residents while supporting a specific needs group of which there is a clear demonstrable need within the council area. If this is indeed the council policy, then what steps have been or will be taken to ensure that only children from within the council area, for want of a better definition of local, will be using this proposed new care home? If the answer is none, then we would maintain that this proposal does not meet the council plan or policies and should clearly be refused.
Thank you, Tracy. Our next registered speaker is Ruth Smith. If you'd like to come forward, Ruth, please. Same arrangement, 3 minutes. I'll remind you 30 seconds to go.
Sorry, I've got Joyce.
Huh?
I've got Joyce.
I'll do that after.
All right, okay.
And just whenever you're ready, Ruth.
I would like to raise 3 serious concerns amongst the many that I have regarding ACAD's proposed development and its alignment with social work services policy, the suitability of the location for vulnerable children, discrepancies in infrastructure assessments. Now, section 4.6 of Mr. McTeer's report refers to ACAD's alleged close working relationship with the local social work department. However, this claim is contradicted by multiple facts. At the Social Work Committee meeting on the 10th of June this year, both Chief Social Worker Stephen Morgan and Councillor Young clearly stated that urban settings are preferred for resettlement of children in care, as this is where most children hail from and would provide greater access to amenities such as gyms, swimming pools and safe play areas. The proposed rural location at Milton directly contradicts this. In fact, Grampian Social Work also have the same mindset and are piloting a programme whereby these homes are being placed in urban locations. So it is obviously an important issue recognised within the social care network. If ACAD work closely with the social work department, why are they not locating this home in an urban setting? Now, ACAD's operational module relies on block booking, whereas the social work department has expressed a clear preference for spot booking arrangements due to the obvious cost implications. This fundamental mismatch raises questions about the suitability of ACAD's model for local children. Consequently, we have been reliably informed by past and present staff of ACAD that almost exclusively children are from out with this area. A Freedom of Information inquiry confirmed that no consultation has taken place between ACAD and the Social Work Department regarding this proposal. This undermines the credibility of ACAD's claim to be providing local care for local children. It's concerning that ACAD staff were advised in May this year, prior to any formal objections, that they would be relocating to Milton. This suggests a level of confidence in the outcome of the planning process that warrants scrutiny, and it would be interesting to know the basis for this presumption. The roads officer assessment under 2.2 appears to underestimate the required parking spaces. Now, the National Roads Development Guidelines for Residential Institutes stipulates one space for one member of staff and one visitor space. Now, based on the ACAD staffing model, 1 manager, 3 supervisors, 6 staff, the requirement is 10 staff spaces plus 1 visitor. That's totaling 11 spaces, not the 6 currently proposed. Furthermore, the applicant has failed to account for predictable visitor traffic. The argument is that you have to get it right for every child. So why are we not striving to do this in this instance? The location of this house is certainly not suitable.
Conclusion, please. Thank you, Ruth. Thank you. Any other questions for Ruth? Thank you for coming forward, Ruth. Thank you. We now have a statement to be read out by our clerk from Joyce Ryman, and then the next registered speaker will come along.
Thanks, Chair. Joyce Ryman, objector. This statement raises significant concerns about the robustness of the planning assessment of this application, particularly in relation to the treatment of community objections, the depth of scrutiny applied, and the apparent reliance on unverified assumptions. It is submitted that the approach taken is inconsistent with the requirements and intent of Dumfries and Galloway Local Development Plan 2 and National Planning Framework 4. 1. Dismissal of residential representations, LDP 2, OP1, H6, MPF 4, Policy 16. Despite 41 objections from local residents, the report largely dismisses these concerns, stating that they are not considered to be sufficient to override the weight given under Section 25 of the Act. This blanket dismissal fails to engage meaningfully with the specific planning concerns raised, including incompatibility with the rural character of Milton, lack of public transport and infrastructure, road safety concerns near a blind bend, insufficient parking and local amenities. Policy conflicts with LDP 2 OP1 requires compatibility with the character and amenity of the area. LDP 2 H6 supports particular needs housing only when it meets locally generated demand and it is integrated into the community. MPF 4 Policy 16 promotes homes in the right locations that meet the diverse housing needs of communities. The absence of detailed analysis or community engagement undermines these policy objectives. 2. Over-reliance on planners' opinion and applicant statements, LDP 2, OP1, MPF 4, Policy 23. The report repeatedly relies on the planner's own assertions and the applicant's supporting statements without independent verification. For example, the roads officer notes missing data on visitor traffic, for example, social workers, family, healthcare professionals, yet the report concludes that there will be no significant impacts. The claim that the development is not significantly disfamiliar to a large family dwelling is made without comparative evidence. Policy conflicts with NPF 4 Policy 23 requires robust consideration of health and safety impacts, and LDP 2 OP1 demands that development proposals not conflict with nearby land uses. 3. Unsubstantiated presumption regarding antisocial behaviour. The report appears to dismiss concerns about potential antisocial behaviour, absconding and the community safety without any support and evidence. This raises a critical question. Why is there a presumption that such a development will not result in antisocial behaviour when no substantiating evidence has been provided? It is unclear whether the applicant has been asked to provide data on incidents that exist in homes operated by a caretaker group within Dumfries and Galloway. If such data were requested and received, it could and should be shared with the local constabulary for verification. This would allow the committee to make an informed decision based on actual operational history rather than assumptions. In handling of this application appears to fall short of the standards required by LDP 2 and MPF 4. The concerns of residents have not been properly addressed. The scrutiny applied is insufficient and key assumptions remain unverified.
3 minutes.
Thanks, Chair.
The next registered speaker is Susan Wallace. If Susan would like to come forward, please. And again, Susan, 3 minutes. I'll remind you with 30 seconds to go. Thank you. Just whenever you're ready.
Thank you. I'm Susan Wallace from Milton. I recognise the need for suitable care home facilities. The concerns I'm bringing to the committee relate to the safety and well-being of cared for residents and confirm that Corbridge House would not be suitable. With regards to the safety of residents and also of staff and visitors, I wish to highlight the lack of any pavements and street lighting in Milton, including at the on-request bus stop at an unlit junction, and also the proximity of the house to a dangerous bend on a narrow road with a 60-mile-an-hour speed limit. Disregarding these dangers surely contravenes the principles of NPF 4 Policy 23 regarding safety. The security and safety of all youngsters is at the core of the Children's Services Plan. Corbridge House is therefore not the right location for the proposed land use. Regarding the well-being of residents, LDP2 Policy H6 includes the need for residential care homes to be integrated into the local community with access to local services and facilities. Such integration and avoidance of isolation are also cornerstones of care policy in Scotland, which aims to, quote, improve the lives of children we care for. Many objections noted the fact that there are no services or facilities within the hamlet of Milton which could enable such integration, such as play parks or community halls. But the planning report fails to address these comments or explain how this integration is achieved by the proposal. This lack of possible integration shows the application does not comply with Policy H6. The officer's report states that the house is in a large plot. The plans, as we've seen, are indeed a conditional of approval very clearly show the bulk of the ground will be car parking, with only a very narrow strip of ground to the rear. The officer's implication that there is a large space for outdoor play is therefore misleading. The lack of such enclosed space for residents, combined with there being no public play space in Milton,
you have 30 seconds to go.
Means the location cannot comply with Policy 23's intent to improve health and well-being. The wider council has a duty of care to the young people in its care. I therefore urge the committee to consider the detail of the application in this light. Failure of this application to comply with planning policies, as I've outlined, must make Corbridge House an unsuitable location and therefore prohibit its approval. Thank you.
Thank you very much, Susan. Any questions for Susan? In that case, thank you very much for coming forward. We now have further 3 representations and then a written statement from Samuel Deegan on behalf of the Planning Potential. But we've got 3 other objectors first. So Tracy, if you can read them, please, and then maybe just pause.
Thanks, Chair. So the next objection is from Mark and Anne White. Whilst we appreciate of the necessity of this type of care home, we feel it's entirely inappropriate to locate a facility of this nature in a rural village like Milton. Consequently, we request that the above application be refused on the following grounds. 1, it is documented in recent minutes of Social Work Services Committee that several members have stated that it is inappropriate to locate this type of care home in rural locations where there are no facilities available, and that they are at best located in urban environments. This echoes the views of most of the inhabitants of Milton. 2, there are no facilities in Milton, and we have a particular concern about the absence of medical and support facilities such as police. It would take an ambulance a minimum of 20 minutes to respond, assuming one was immediately available, and in reality probably considerably longer. Police Scotland response times due to staff shortages could be very lengthy should an incident occur. Incidents commonly occur at other care homes of this nature. 3, there is no land available to provide any form of leisure facility within the site of the application. 4, much of the applicant's later response in respect of the activities they intend to provide for the residents is more idealistic than factual, and clearly is a statement made purely for planning permission purposes, a statement somewhat different to the original application. From experience of other similar care homes in the region, these ideals are unlikely to be fulfilled in practice. 5, there are a number of inconsistencies in the planning application, and the applicant has changed some things, such as their proposed staffing levels. To ourselves, this is a red flag. In the event of this application being granted, the applicant will be able to make further changes to their operational of this property, which may have an additional impact on the residents of the village. 6, Social Services Committee are currently considering their future policy for this type of care home, as it has become prohibitively expensive for the council to use this type of facility. 7, despite the advice from the Roads Department, there is an issue with parking and traffic. Additionally, no mention has been made of provision for delivery vehicles. If all the car spaces are in use, where do these park, even on a short-term basis? Clearly, any parking on this stretch of road would be extremely dangerous. 8, the danger of this stretch of road are highlighted by 2 recent accidents. Last year, a speeding agricultural vehicle overturned in the village, depositing a trailer load of silage onto our property. The silage reached our first floor window level. A recent fatal accident emphasises the real dangers of that section of the road. A child wandering along that road, which has no curbs, would be in danger. 9, as there are unresolved legal difficulties with the Barber brothers, we cannot see how this application can proceed until these have been resolved. 10, almost all the residents in the village of Milton have objected to this proposal on the grounds that it would have an adverse impact on village life and that it will impact on their lives. Planning policy clearly states that a planning proposal should not affect the amenity of other properties.
3 minutes.
The next statement is from Sarah White, objector. I believe Corbridge House in Milton Village is not a suitable property for the proposed care home. As stated previously, the property is on a large plot. However, majority of this plot is a car parking and turning area to the front of the property, leaving little to no recreational space outside. There is also no nearby option for this, and the properties exit straight onto a busy 60-mile-per-hour road with no footpaths for walking and no nearby parks or suitable green spaces. As a parent with 4 children, including one with complex needs, I appreciate the need for access to a safe play space that children need. Access to outdoor space has so many proven benefits to both physical and mental health and well-being, and I believe the residence of a care home of this nature is absolutely essential. Corbridge House does not offer this, and I do not believe it is a suitable property for the proposed care home. The last statement from the objectors is from Lee Whitehead. Milton is a hamlet, not a village, not a town, a hamlet with no public transport, no pavements, no street lighting, no shops, no community hall, no shared spaces, no park and no medical facilities. And yet this council is considering placing a 24-hour care facility here for vulnerable residents who would depend on every one of those missing services. This is not just poor planning, it is dangerous. In July, a young man died in a crash on the road less than 25 metres from the proposed site. The road is narrow, unlit and already hazardous. Both the original transport report and the council's own response ignore this entirely. They also ignore the fact that ambulance response times in postcode DG2 regularly exceed 20 minutes, well above national targets. And when emergency services do arrive, they often have to close the road to all traffic for several hours. The strain this care home would place on emergency services affects not only high dependency residents, but every other person in Dumfries who may be left waiting in their hour of need. A delay like that could be fatal. The council has passed responsibility onto statutory consultees, Scottish Water, SEPA, the Roads Authority, but none of them live here. None of them walk these lanes. None of them have considered the wider impact of placing a commercial business in a rural hamlet. They haven't addressed the increase in traffic and population. They haven't addressed the disruption to the the setting caused by 10-foot high fences that are completely out of character with the rest of Milton. They haven't addressed the light pollution from security lighting, and least of all, they haven't addressed the impact on any future residents of this facility, especially when the proposal intends to turn their only garden and outdoor space into a tarmac car park. Research from the Local Authority Association and the Impact Network shows that care homes placed in areas without community infrastructure suffer from isolation, poor staff retention and reduced well-being. Milton has none of the facilities required to support residents or staff. The Council's report fails to address this. It fails to explain how a care home will function in a location with no transport, no amenities and no emergency resilience. This is not a minor change, it's a commercial operation in a fragile rural setting. Sets a precedent that undermines the integrity of planning policy and the safety of our community. I urge the committee to reject this application, not just for what it is, but for what it represents: a failure to protect the vulnerable residents of Milton, a failure to respect rural infrastructure, and a failure to listen to the people who live here. Thank you, residents of New York Steading. Sorry, that's it, Chair. Thanks.
Thanks, Tracy. That concludes representations from the objectors, whether it be statements or in person. We have one speaker on behalf of the applicant, which is an agent. It's Samuel Deegan, a director on behalf of Planning Potential, and it's a statement that Tracy will read out. And again, it's 3 minutes, then we'll just cease at that.
Chair, so this is on behalf of the agent. The applicant is delighted that the Planning Department has recommended this much-needed proposal for approval. The applicant is a well-established residential care provider that has operated in Dumfries and Galloway Council region for over 20 years, with several services across Scotland. However, the majority of their services are within Dumfries and Galloway. The care model seeks to provide nurturing care and support to children in a manner that aims to replicate a family environment as closely as possible. This has been successfully achieved in all other services, and the proposed service has the same aims, with registration being for only 4 children. The majority of the applicants' current referrals tend to be children in the age range of approximately 6 to 12 years, with particular success in recent years with small sibling groups where a more homely family environment has been achieved. This property has been selected as it is very well presented and provides suitable accommodation for 4 children. The layout would allow us to provide an ensuite bathroom for each of the children's bedrooms and has ample accommodation in the public rooms and grounds. As indicated, the applicant has several services across Dumfries and Galloway, and one of their other services approximately 15 minutes drive from the proposed service. This would allow them to utilise the support and experience of the managers and care workers at the existing service to establish the same high standards at Corbridge House. The applicant also has its own independent school approximately half an hour's drive from the proposed service. They would be transported to and from school, therefore limiting the impact on local infrastructure. The majority of the applicant's children's houses are in rural, semi-rural locations, and they therefore have considerable experience of working closely with local communities, neighbours and other professionals to ensure that the effective running of their services. That's it, Chair. Thanks. Oh, sorry. I think actually there's a second page, sorry. The children they care for access activities and amenities in local communities, towns and cities, just as family living in semi-rural and rural locations would do. The care workers ensure that children are transported safely to and from school and all relevant services and activities. There is sadly significant demand for this services, with many of the applicants' current children from the Dumfries and Galloway area living out of the area due to limitations in the area availability. The applicant has also received numerous referrals from social workers regarding placing children, but they haven't been able to accommodate them due to placements being unavailable. The applicant has a robust matching process in place whereby they work closely with social work services to review potential childcare referrals to ensure they are well matched and compatible with other children at the services as well as the location. Social work colleagues have highlighted the importance of placing and maintaining children within the area wherever possible, and this support better outcomes and enables them to maintain important relationships and connections. Placing children in a location that allows them to maintain links with family, friends and their community provides the best opportunity.
Thanks very much, Tracy. Members, we've heard from representatives and from the agent. We're now in session. Councillor Dryburgh, please.
Thanks very much, Chair. And, you know, listening to the objectors, I feel, I feel their concern, and I think most of them have said that there's a lot to do with the rural location and the bad roads and little room in the back garden for play for, you know, potentially for children between 8 and 12-year-old, as the applicant has actually said. I'm just wondering, Chair, if it might be appropriate that the Planning Applications Committee do a site visit to look at all these issues in one, and I'm happy to propose that if that's a way forward.
Thanks very much, Councillor Jordan. I'll invite you in, but normally we cease debate until we decide whether or not a site visit is appropriate, unless you're looking to either make an alternative or proposed or support Councillor Driver. Councillor Jordan, please.
No, thank you, Chair. I was going to say something else. So if you wish to cease debate until we've decided whether a site visit is suitable, then that's fine. I don't think we do need a site visit, but I'll let others speak on that. Thank you. And I'll come back with my point a bit later. Thank you.
Thanks very much, Councillor Jordan. Councillor Kim Lowe, please.
I would second the proposal for a site visit.
Thank you for that, Councillor Lowe. Are there any alternative views? We don't go further into discussions, Councillor Jordan, unless you're going to propose an alternative. So, Councillor Jordan, Councillor Giusti.
Yeah, thank you, Chair. I was going to propose an alternative. I don't think there's need for a site visit. I think we have enough information in front of us, so I would propose that we can make a decision today. Thank you.
Thank you, Councillor Jordan. Councillor Giusti, Andrew.
I'll second Councillor Jordan.
Okay, we don't need any further debate. We'll go to the vote. Tracy, just remind members what the motion amendment is, please.
Thank you, Chair. So the motion is proposed by Councillor Drybrook, seconded by Councillor Lowe, and that's to defer consideration of this application to allow for a site visit to be arranged. The amendment proposed by Councillor Jordan, seconded by Councillor Giusti, and that's to determine the application to date without the need for a site visit. Chair?
Amendment.
Vice Chair?
Amendment.
Councillor Blake?
Motion.
Councillor Blake?
Motion.
Motion, thank you. Councillor John Campbell?
Motion.
Councillor Giusti?
Amendment.
Councillor Hill?
Amendment, please.
Councillor Hislop?
Motion.
Councillor Maureen Johnston?
Amendment.
Councillor Jordan?
Amendment, please.
Councillor Lowe?
Motion.
And Councillor Thompson?
You're not going to ask me?
Motion.
Sorry, Archie, you're not on my sheet. Sorry, Councillor Driver.
Motion.
So we've got 6 votes for the motion and 6 for the amendment. Chair, would you like
Are
to?
we sure we've asked everybody? Because I thought Archie interrupted somebody else. Aye, Stephen Thompson.
Councillor Thompson, I had used the motion. Was that right, Councillor Thompson?
Yes, that's correct.
Yeah.
6.
Yeah, we've got 12 members present, Chair.
6-6, okay, I'll go with amendment.
Amendment. So Chair has used his right to the cast and vote, which went with the amendment, so the application will be determined today without the need for a site visit. Thank you, Chair.
Thank you. So members, again, we're in session. Councillor Jordan, please.
Thank you very much, Chair. I just wanted to raise a couple of points. It's been mentioned that there's a particular need for this type of housing under LDP 2, policy H6. But actually, the Social Work Services Committee did speak about smaller properties for children, but not that council-run properties, and properties that were in more, I can't think of the word, I'm sorry, not rural areas. So I actually disagree with that point at the moment, and I also am very concerned about facilities for these young people, because I think this is a rural location and connectivity concerns me. Thank you.
Thanks very much, Councillor Jordan. I don't know whether that was a question for Chris or no, but we're in session anyway, so we'll just proceed with that, your view at the moment, and come to Councillor Giusti, please.
Hi, Chair. It's a question about if we were to maybe look at a refusal here, because I have got quite a lot of sympathy with the objectors. Looking at what would have been our last item, which is the Cairn Ryan Hotel, when we look at the recommendations for refusal there, I feel like we can draw upon those recommendations here, which is MPF 4 Policy 13, and the lack of public transport, the lack of sustainable transport, and the lack of like pavements and everything like that. I'm just going to ask David, is that competent?
Okay, well, the case officer's here first. We'll ask Chris and then we'll come to Mr. Sutty.
I'm not sure that's really one for me, given my recommendation, so I'll pass that over to David.
Sutty. David, and then we'll ask Laura Whitelaw, our legal advisor.
Certainly looking, I mean, you're obviously referring to the McDonald's application at Cairn Ryan that was withdrawn. The level of traffic which that would generate is very materially different to what this proposal would be. So that in itself, I don't think is properly competent grounds to refuse it, to be honest. But if members are concerned about it, then I think Councillor Jordan probably hit more of a nail on the head in terms of policy H6 and the access to local services and facilities. If that is something members are concerned about, there probably is some mileage in that being a competent ground.
Okay, before I go to Councillor Johnson, anything to add, Laura, to that advice?
Only to mention that in the item that was withdrawn, it was specifically for a drive-through, which by its very nature, the proposal was indicating that it was expecting a high degree of transportation going to, whereas this is for a residential property.
Thanks very much, although I'm sure you'll have taken account, Councillor Giusti, of the observations of our development manager, Mr. Sutty, saying that Councillor Jordan hit the nail on the head, so if you indeed want to put forward a proposal to refuse, you might want to consult or discuss with Councillor Jordan. Councillor Maureen Johnson, please.
Thank you, Chair. I would just like to go back to a point that was made by the applicant on his letter there. The applicant states that he works closely with the social work department. During our meeting, the social work meeting on the 10th of June this year, Stephen Morgan, our chief social worker, was questioned on this aspect of this home, of putting children into either rural locations or urban. A councillor raised the point, and Stephen Morgan, our chief social worker, replied, "I would fully support your views on that we want homes for children and we want those to be similar to what they are used to. And the vast majority do live in towns and would like to remain in those." Stephen Morgan then goes on to say, "I wouldn't like to be pressed on the location as that is not my job. Has the chief social worker been given any input into this planning application?"
I think the answer will be no, but Chris did make reference to reports from the Chief Social Work Officer in his presentation. Can you just confirm whether or not you had long discussions or any discussions with Stephen Morgan, please, or indeed have taken account of committee reports?
Committee reports, yes. Those are obviously in the public domain, and I took those as part of, I suppose, a joined-up approach to that. But we didn't specifically consult with social work on that, because we are just looking at the use. I think if we were going down that particular route. It's looking more towards, you know, what kind of sort of localised demand there are, and we are just looking at the use of that. That was just a bit kind of beyond what I was looking at for this.
I'll ask Mr. Sutty if he wants to add anything, but you would know that Chris has made reference to Social Work Committee reports in his presentation to us. Mr. Sutty.
Thank you, Chair. Obviously, just as Chris was saying, what we're considering at the Planning Applications Committee today is the land use planning issues of the use of the building. I believe that there would probably, through the Care Commission, I'm not an expert, sorry if that's wrong, but be a separate licensing side of things for the operation of that side of things. But really, although the applicant has been referred to many times by the objectors, we've got to look at this on the basis that planning permission runs with the land, so it wouldn't necessarily be them who could benefit from this planning permission. Anybody could actually use it for the same purpose. So I don't know if that really helps, but I think there are two separate mechanisms for looking at this.
I think we did say that Councillor Jordan had hit the nail on the head, and therefore there was an opportunity. If Councillor Jordan was to formulate a proposal against this application, it would be competent. Is that right, Mr. Sutty?
Yes, I mean, obviously, as Chris said, it's awkward for us because of the recommendation that we've put forward, but bearing in mind the comments which we've heard today, I think if you're looking for a competent ground, I would suggest members look at policy H6, and particularly that last line in there about particular needs housing should be integrated into the local community. And then this is the critical bit, with access to local services and facilities. Milton is a small building group in a rural area, so members can come to their own conclusion as to whether or not that does comply with policy H6 and LDP2.
Thank you. So I did see Councillor Jordan's hand up and then go back down again. Have you decided against speaking, Councillor Jordan, because I have Councillor Driver on the list?
Thank you. I'll let Councillor Driver go first. Thank you.
Thanks very much, Councillor Jordan. Councillor Driver, Archie, please.
Yeah, thanks very much, Chair. And I think I would suggest that we do not agree with the recommendations in this particular report because of the particular needs housing in policy H6, and in particular the location to support services in more urban areas as opposed to the rural areas. I also think policy 23, health and safety for road use as well. As we know, young people tend to run about if they're not being fully supervised. I would hate to think that our social services people, or at least the people from the company, would be keeping a good eye on them, but they are, you know, as you're aware, the young people tend to do whatever they want and no listen to people. So I would say I would go against the recommendation and not allow this to happen because of the policy H6 and policy 23 for National Planning Framework 4.
Thank you, Councillor Driver. I've got Councillor Jordan looking to speak, please.
Thank you, Chair. Yeah, I would like to second that recommendation to refuse this planning application based on the things that Councillor Driver has said. Thank you, if that's competent. Thank you.
Thanks very much. I'm sure it'll be competent. I'm looking for any alternative proposals. If there's no alternative proposal, just check with Mr. Sutty and legal that that is indeed a competent motion.
Thanks, Chair. I'm comfortable with, when I'd been scribbling down notes as we went on there, but what I had put down was that the proposed change of use of a dwelling house Class 9 to a residential care home Class 8 is contrary to Dumfries and Galloway Council LDP2, Local Development Plan 2 Policy H6, in that Milton is a rural small building group with no local services and facilities, and as such it is not capable of properly supporting the proposed particular needs housing. I note what Councillor Driver is saying about policy 23 of NPF 4 on health and safety. That one I'm less comfortable with because it's already a dwelling house, which you could have children come running in and out of, etc. So I don't think the use in itself is self-evidently a health and safety risk in terms of children running onto the road. So I would take advice from Laura on that as well. But certainly the first ground I'm satisfied is competent on those.
Before I go to our legal advisor, Councillor Driver, are you happy to refrain from proposing the second element? And
Yeah, happy to change that, Chair, just to policy H6.
Super duper. And Councillor Jordan, are you happy to go with what Councillor Driver has changed to?
Yes, thank you very much, Chair, yes.
Thank you. And last move to Laura. Is that a competent and acceptable proposal?
Yes, thank you, Chair. My concerns over the transport, health and safety have been removed.
Thank you very much. In that case, we have a motion and a supporter to refuse this application on the grounds set out. Are there any alternative views? In that case, the application has been refused. Can you confirm the decision of the committee, please, Tracy?
Thank you, Chair. So members have agreed to refuse the application on the grounds that the development, which is a change of class from class 9 to class 8, would be contrary to LDP2 policy H6 due to the particular needs at this rural location and Milton being a small building group, not supporting the particular needs of those requiring use of this facility due to no access to local services and facilities within this rural location.
Thank you very much. That concludes agenda item 7. Thank you very much for being present here today, folks. Would somebody invite Councillor Drysdale back in, please, and then we'll recess for lunch. Right, members, we'll recess for lunch. 13:50, 10 minutes to 2, we'll resume. Thank you, everyone. Afternoon, members, welcome back. Move on to agenda item 8 on the planning application papers. It's an application for the erection of a transport hub with roof-mounted photovoltaic panels incorporating provision of secure bicycle locker, storage for bicycles, e-bikes, electric bicycles, and ACC bikes, accessible electric bicycles, bike wash, pump, repair station, bus waiting area with fixed benching and shelter, and installation of one electric vehicle charging unit at Fleet Vale Car Park, Gatehouse of Fleet. It's the full application, reference number 25/1189/full. Recommendation is approved subject to conditions, and although the case officer in your papers is Iona Brooke, it's Rachel Lightfoot that's going to take us through this report. So, Rachel, whenever you're ready, please take us through your report.
Thank you, Chair. Good afternoon, councillors. This application is before you has been made by Dumfries and Galloway Council. As noted, the application is for a transport hub providing storage for e-bikes, accessible bikes, a replacement bus waiting area, bike wash and repair area. Additionally, 2 further spaces within the car park will become EV charging spaces. 1 tree will be removed, 1 relocated, and 3 new trees planted. An area will also be provided for the Christmas tree. Turning to the presentation, the location plan, the existing site plan, you might not be able to see it, but there is a note that the COVID memorial tree will be resited within the immediate area. Proposed site plan of the new transport hub with the 2 spaces to be allocated for EV charging. The proposed elevations of the new hub showing stone feature walls, a sedum roof with PV panels and cathedral cladding. This is what the proposed EV charger will look like within the existing car parking spaces. So turning to the site, a view looking north towards the hub site. This tree will be removed. View looking east towards the hub site. Looking south, that bus seating area will be removed, the bus stop will remain, and the seating area will be provided within the hub structure. Just looking east again over the site towards the car park. Looking west, and then the 2 spaces in front of the tree that you can see centrally will become EV charging space points. That tree has already been removed prior. In relation to the responses, the council's flood team have raised an objection as there are areas of surface water flooding nearby. However, as the application is for improved public infrastructure supporting sustainable transport and would not be used by members of the public for extended periods of time, hoping that they would therefore be aware of potential storms and the impact of flooding, the benefits of the hub are considered to outweigh the risks. This is covered in paragraphs 4.10 to 4.11 of the report. The application has been subject to 5 objections relating to the loss of the tree, the loss of 2 non-EV charging the loss of 2 non-EV parking spaces, potential highways issues, the design of the development and other sites being more appropriate. In relation to these, whilst one tree is to be removed, 3 additional trees will be planted. This is covered in paragraph 4.14. The provision of the EV charging points promotes sustainable modes of transport, which is covered in paragraph 4.5. The design is considered by officers to be acceptable and the hub centrally located. This is covered within paragraphs 4.6 and 4.7. There have also been 16 late letters of support, 2 further letters being received following the finalisation of the report. The application is recommended for approval, subject to the conditions relating to the standard length of the approval and also to ensure the compensatory planting is provided. Thank you.
Thank you, Rachel. Any questions for our case officer? Councillor Beretti, Tony, please.
Yeah, thank you, Rachel. Now, I know you are doing this for Iona. Have you perchance seen the site yourself? Because that site there, knowing it well, there are already EV charging spaces on the left as you go in. And frequently, when I go in there, I also see internal combustion engines parked in the EV charging spaces. So have you seen that per chance?
Yeah, I'm aware that there's EV charge. I have been out to site, but yeah, there are charges and we can't stop people parking in those EV charging points. We just have to assume that as EV vehicles become more popular, as the prices continue to come down, the infrastructure's in place to deal with them.
Thanks, Councillor Beretti. Any other questions for our case officer? Councillor Drysdale, please.
Thank you very much, Chair. Just a quick question. We have been looking at these hubs and in particular the design looks particularly pleasant, but I was just wondering, with this application, I don't see it in the paper, so I'm assuming it's not included, but the totem whereby people can get access to Wi-Fi, if, for example, for bus timetables and things, is that excluded from this one or included? Thank you so much.
Rachel.
So we do have some BT access points, the hubs that are going through BT. There isn't one in this application at the minute, and BT are putting those applications in separately. So there is one at the Sands at the minute for a hub.
Thanks, Councillor Drysdale. No other questions for our case officer? We're in session. Councillor Dryborough, please.
Agree the recommendations, Chair.
Thank you, Councillor Dryborough. Councillor Drysdale.
Happy to second, Chair.
Thank you, Councillor Drysdale. Are there any alternative proposals? If not, can you confirm the decision of the committee, please, Tracy?
Chair, members have approved the application subject to the conditions detailed in the report. Thanks.
Thank you, Tracy. Move on to agenda item number 9, an application for the erection of a transport hub with roof-mounted photovoltaic panels, incorporating provision of secure bicycle locker storage for bicycles, e-bikes, which are electrical bicycles, and ACC bikes, accessible electrical bicycles, bike wash, pump, repair station, bus waiting area with fixed benching and shelter, and installation of 2 electric vehicle charging units at Dashwood Square, bus stops and car parking, Newton Stewart. Full application reference number 25/1192/full. Recommendation approved subject condition, and again, although case officer Iona Brooke, Rachel's going to take us through this presentation. Rachel, whenever you're ready, please.
Hello again. This application again is before you as it's been made by Dumfries and Galloway Council. Again, seeking permission for a transport hub to provide secure storage for e-bikes, accessible bikes, bus waiting area, bike wash and repair station. Additionally, again, we have 2 EV charging stations this time for 4 car parking spaces, and the hub itself. In this application, there are the proposed replacement of 2 existing bus stops, and they will be proposed with 2 new timber-clad green roof bus stops. Turning to the presentation. So we've got the location plan, the site plan as existing. You can just see the 2 separate red areas, which are the bus stops, which will be replaced through this proposal as well. This is the existing elevation, so we have a pagoda, I will call it, for want of a better word, structure, which will be replaced by the hub, and then the 2 bus stops, as you can see on the top elevation. The site plan as proposed, showing the hub, and again the 2 red boxes which are separate are the replacement bus stops. The proposed elevation of the hub, this time you can see cedral cladding to all elevations with the sedum roof and the PV panelling to the roof. The EV chargers as proposed, similar to the last application. Again, there'll be 2 of these affecting 4 car parking spaces. So this is the view looking towards the site from looking north. The view looking west with the current structure, which will be replaced by the new hub. This wall will be broken into to provide an access ramp to the hub and the EV charging spaces. The view of the current area of car parking, which 4 car parking spaces, so the nearest 4 from the two white cars and the 2 silver cars will become EV charging points. View of the site looking south. This is one of the bus stops which will be replaced with the new timber bus stop. The second bus stop to be replaced. There are no objections from statutory consultees. We've received 2 objections from the community in relation to parking and manoeuvring and the area being prone to vandalism. In relation to these objections, parking arrangements are not altered generally by these proposals. The provision of the EV charging stations provides support for sustainable transport modes, and this is covered in paragraph 4.11 and 4.4 to 4.5 of the report. In relation to antisocial behaviour, Police Scotland were consulted on the application but did not provide any response. Issues of antisocial behaviour are within the remit of Police Scotland and not within the remit of the land use planning system. This is covered within 4.16 of your report. The application will provide enhanced community facilities and in their doing is recommended for approval. Thank you.
Thank you, Rachel. Any questions for our case officer, Councillor Drysdale?
Thank you, Chair. Thank you, Rachel. Quick question. Did you say timber bus stops? Is that the general recommended design in the transport hubs? And if that is the case, which is obviously very in keeping with the countryside and natural environment we live in, but is the timber treated for ageing? And also, if it is vandalised, and I hope it wouldn't be, but if it is it easy to remedy that situation as it is at the moment sometimes in the plastic exteriors of the bus stations that we have, although we know a lot of the glass and plastic systems get destroyed, but it was just to double check that. Thank you very much. Thanks, Chair.
So in terms of the replacement bus stops, the only information that we have been given is timber clad. So that should reduce the potential for kicking the glass out, etc., that potentially you've got now, and it should make it easier to power wash off.
Thanks, Councillor Drysdale. Any other questions for our case officer? Oh, Councillor Beretti, please.
Yeah, thank you. I just remembered that there is a fountain. There was a design fountain at the start of the wall. So if you go back, you'll see that. Is that actually still being retained?
Sorry. I'll have to double check that for you. I think it is, but I wouldn't like to absolutely confirm that it is.
Content with that, Councillor Beretti? Aye. Thank you. Okay, are there no other questions? We're in session, members. Councillor Campbell, please.
Yeah, I see in the report about contaminated land, and it says it would be prudent to put a directive on there. That's in 4.15. So if members are happy with that, I'm content to approve subject to conditions, Chair.
I'll just check with Mr Sutty and Laura, a directive on contaminated land, David and Laura.
Yes, happy to attach that, Chair. Sorry, I was slightly distracted. We're just double checking the plans here, and to answer Councillor Beretti's question, the existing features shown as being retained.
That's really helpful, thank you. Laura, contaminated land, okay?
Yes, thank you, Chair.
Thank you. Councillor Driver, please.
Happy second.
Thank you very much. Alternative proposals? In that case, can you confirm the decision of the committee, please, Tracy?
Thanks, Chair. Members have approved the application subject to the condition in the report with the directive attached on contaminated land. Thanks.
Thank you very much. Move on to agenda item number 10. An application for the extension to existing water treatment works, including erection of water treatment building and 3-metre high security fencing, siting of workshop, 2 salt saturators, 1 pump kiosk, 1 substation and transformer kiosk, generator and fuel storage kiosk, 1 service water kiosk, final meat mixer kiosk, 2 raw water tanks, 6 permeate tanks, 1 chlorine tank, 1 sample kiosk, 3 lamellas and associated buildings, formation of suds pond, landscaping and groundworks and alteration to access. Amended plans have been received at land to the east of Black Esk Water Treatment Works, B723, Borland House, Borland. This is a full application, reference number 25/0175/full. Recommendations to approve subject conditions, and the case officer is Graham Smith. Graham, if you're with us, can you take us through your presentation, please?
Thank you, Chair. Good afternoon, everyone. The first slide shows the location of the site. As you can see, it's in the rural area with extensive forestry in the vicinity and no nearby settlements. There's a cluster of cottages at Sandyford Bridge to the east of the site, but other than that, it's a remote part of the countryside enveloped by trees. The B723 is a road running past the site, which provides access and is connecting Eskdale Muir to the northeast and Borland to the southwest. The Black Esk Reservoir is to the north, and its river runs down the valley to the east of the site. The next slide shows a couple of overhead maps. The area where the development is proposed is adjoining the existing Scottish water infrastructure. These are SEPA flood risk maps indicating that the site itself is not at risk of river or surface flooding, albeit there have been some incidents in the wider area. As you might expect, the floodplain is further down towards the river. The next slide is a drone photo of the site, and the area that has been cleared of forest is where the development would be occurring. So you can see the existing infrastructure on your left, which this application seeks to extend, and residential cottages in the top right corner past the trees. The next slide shows the habitat within the site, which is typical of a recently felled forest. The next is standing in the site looking downwards to the east. And the next couple of slides just shows views from the road. This one is coming from the west with the existing facility on your left. The other one is approaching the site from the east. So the area to be developed would be on the right-hand side, past the trees. The next slide shows a proposed layout plan. A new access would be formed off the road, leading to an area where the infrastructure would be developed. What is happening on site is a process requiring several bespoke components, many of which are housed in a collection of kiosks and cabinets. It should be noted that some aspects of the proposal are permitted development, with the applicant being a statutory undertaker. Probably the most impactful part of the development would be the new water treatment building, which is shown in the next slide. It's a shallow pitched roof industrial style unit measuring 12 metres in height, approximately 2,000 square metres. The applicant has selected a recessive green colour cladding for this in an attempt to better integrate it into its surroundings. We can move on to the next slide. You can see from this view quite clearly how the site would function and relate to the existing waterworks. I would point out the pond in the top right corner. That's part of a drainage strategy which has been assessed by our experts who, as I've stated on page 155 of your papers, are satisfied that a sustainable solution has been arrived at. The next two slides simply show a visual representation of how the development would look. I would point out that this shows a previous version of the water treatment building. The design has since changed during the course of the application, and I think the applicant will provide you with an updated montage in their presentation. The height of the revised building has been reduced by about 4 metres, so what is proposed is less prominent and impactful than what is shown here. You can see it just beyond the trees. Regardless, I've still concluded that with the recessive colour scheme, trees intervening in topography, I do not consider it to be prominent in terms of its visual impact in this landscape setting. So that's from 2 Sandyford cottages on the road, and the next slide shows from the driveway of 1 Sandyford cottage. Whilst I've concluded that the visual impact is acceptable on page 161 of your papers, should you be minded to go with my recommendation, I recommend a condition that would give us some control over external lighting, which can help prevent any unnecessarily light pollution and further mitigate the landscape impact, particularly in the winter months. If we can move on to the final slide, I anticipate that in their presentation the applicant will emphasise the wider benefits of this infrastructure to the people of Dumfries and Galloway. From a planning perspective, I would add that it does contribute to meeting one of our overarching objectives of LDB2, which is maintaining or enhancing water quality. The development is big and would make an incursion into part of the countryside, but I consider that the design integrates well into the local context, and it should be noted also that the applicant is committed to providing a further 2 hectares of native broadleafed woodland at Black Esk by the end of 2026. This approach to ecology aligns well with those parts of the development plan that promote enhancements to biodiversity. Some concerns arose during the course of the application with respect to drainage, but I believe these technical matters have been resolved, with the consultees now satisfied about what's proposed. On this basis and on the whole, as I've stated in the report, notwithstanding points made by objectors, I do consider that what is proposed accords with the development plan. I therefore recommend that the committee approve this application today, subject to the conditions listed on page 160 to 162 of your papers. Thank you.
Thanks very much, Graham. Any questions for our case officer? Councillor Dryborough, please.
Yeah, thanks, Chair, and thanks, Colin. I'm just looking at page 162 of your recommendation, number 15, that all external lighting within the site shall point down in a downwards direction and shall be cowled to avoid any spillage of light above the horizon. Are you suggesting that should be agreed with the officers as part of the planning team, or are you just happy with the way things are there?
Well, one of the things I would probably say is that I've just having read this morning, there is another condition in there looking for a scheme of lighting. So that's number 8, which is on page 161. That last condition that's put in there could potentially be omitted if you were agreeable to that, because I think condition 8 requires a scheme of site lighting to be submitted to and approved by us in consultation with roads. So yeah, okay. That number 8's probably better. A bit of a mistake adding that extra one on at the end.
Okay, thank you.
And you can take that, Councillor Dryborough.
I am, Chair.
Thank you. Councillor Drysdale, please.
Thank you, Chair. Thank you very much, Graham, for the report. I just want to look at page 159 under ecology 4.15, the last sentence. A number of mitigation measures are recommended by the ecologists. So on 4.16, we see that the company have put in mitigation measures whereby they've planted broadleaf trees at Ettrick and 2 hectares of native woodland at Black Esk. So that covers a fair bit of it, but not the actual site itself. So I was just going to ask you, Graham, can you let us know in the recommendations at which point would include the hedgehog habitats, the bird nesting boxes, the pond creation, ditch improvements, and lastly, pardon me, I've gone too bit, the wildflower planting, the species-rich hedgerows and living roof on buildings. Is that covered in the recommended decision? Because I'm probably missing it, but I can't see it clearly on that, if it's possible to confirm that. Thank you so much.
You're welcome. Condition 14 on page 162. That requires the recommendations made by the ecological appraisal to be implemented in full, and those recommendations that cover works during the construction process for making sure that the construction's not the checks before the construction, then during the construction measures, and then post-construction, that those biodiversity enhancements are implemented in full.
Happy with that, Councillor
I am
Bryce?
happy with that. Thank you very much, Graham. Thanks, Chair.
Any other questions for our case officer? In that case, we come to our registered speaker on this agenda item, Carla Mann, on behalf of Scottish Water. Would you like to come forward, Carla, please? And if you're bringing a colleague with you, there will be a 5-minute opportunity to address the committee collectively. And then if you be kind enough, I'll remind you 30 seconds to go to bring your presentation to conclusion. And then if you'd be kind enough to wait, you might have questions for you. So whenever you're ready, Carla, thank you.
Presentation. Okay, thank you. Okay, hello, I'm Carla Mann. I'm Scottish Water's planning advisor, and I would like to highlight our goals and benefits this essential infrastructure improvement at Black Esk would bring if granted. Next slide, please. Black Esk Water Treatment Works has been operational since 1987 and can supply over 21 million litres of water to around 40,000 customers across several towns. However, challenges have naturally emerged due to the ageing infrastructure causing water quality issues. Scottish Water is focusing on improving its systems to meet regulations, maintain network reliability, and ensure the water supply remains safe and adequate for the area. Next slide, please. The Drinking Water Quality Regulator, or DWQR for short, is responsible for overseeing and enforcing water quality regulations. Due to past contamination and disinfection problems exceeding regulatory limits at Black Esk, this has led to heightened scrutiny by the DWQR, and Scottish Water has committed to improve the site's water quality. Therefore, the proposed upgrades to Black Esk are necessary to fulfil these commitments and legal requirements with the DWQR and the catchment area. Next slide, please. An assessment of upgrade options revealed that simply refurbishing the existing water treatment works would not adequately address the water quality challenges, nor would it be possible to keep it operational during these upgrades. Consequently, a new site adjacent to the current facility was selected to integrate new treatment assets while leveraging the raw water source and existing infrastructure. The chosen land was previously a commercial forest and was mature for felling, making it a practical choice for development with minimal additional environmental disruption. Next slide. The chosen site allowed the optimum positioning of the new water treatment building to use gravity for efficient water flow, reducing the need for more equipment. Our key priorities then arose during community consultation event, where we listened to community feedback and revised our original design of the main water treatment building to reduce its size and, most importantly, height from 16.8 metres to just over 12 metres to minimise visual impact. Additionally, we have chosen to use transportable treatment units, which are built off-site and delivered to site, which will reduce disruption to the local community by speeding up construction time and reducing on-site labour requirements. Next slide, please. Environmental sustainability has also been central to the project design. Plans are to include approximately 2 hectares of tree replanting to restore native habitats and provide natural screening for the facility. A comprehensive landscaping plan will also introduce biodiversity enhancement beyond tree planting. The proposed Suds Pond, which manages surface water runoff to prevent flooding and improve surface water quality, would also create a dynamic habitat that supports local wildlife through fluctuating water levels. Next slide.
The access road design was refined throughout the planning process following consultations with community members and Roads Authority. The chosen access point was moved away from residential areas in Sandyford to reduce noise and disturbance. The new location improves driver safety with better visibility on the B723 road and requires less groundworks, ensuring an existing mature tree belt for visual screening is preserved. Next slide. This 3D model offers a visual representation of what we believe the development would look like once it has had time to settle in and vegetation has matured. This image shows a viewpoint from the east along the B723 near to the residents of Sandyford, looking to the west towards the extension. The visual model has been developed using accurate scaling of the buildings within the site. Next slide, please. Extending the Black Esk water treatment works brings multiple benefits. It aligns with regulations and improves water quality for the catchment area. Utilising the existing site and buildings along with the new upgrades reduces environmental impact, lowers costs for customers and accelerates the improvements. The project also incorporates ecological enhancements which wouldn't have been achievable if the land was to remain as commercial forestry. Finally, the use of the TTUs offers reduction of on-site construction time and disruption and reduces the project's carbon emissions. Thank you.
Thank you very much, Caroline. Thanks for being brief. Any questions for Scottish Water's representatives? Okay, so thank you very much for coming forward. Thank you. Members, we're in session. Councillor Dryburgh, please.
Agree with the recommendations, Chair. I would suggest that we take 15 out because it's already covered in 8, the conditions.
Okay, I'll just clarify that with the case officer first and then with Mr Sutton, if members are happy with that. So, Neil, if you're still there, Graham, sorry, even.
Yep, I agree with that. Put my hands up as kind of double repetition there, so it's unnecessary.
Okay, members, given that our case officer agreed with Councillor Dryburgh, he's proposed that we go with this recommendation. Councillor Drysdale.
Happy to second, Chair.
Thank you. Any alternative views? In that case, can you confirm the decision of the committee, please, Tracy?
Thanks, Chair. Members have approved the application subject to the conditions detailed in the report with the removal of condition 15. Thank you.
Thank you very much indeed, Tracy. Move on to agenda item 11, an application for the erection, 35-year operation and subsequent decommissioning of a wind farm comprising of up to 9 wind turbines and associated development at variance with conditions 1 and 11 of planning permission PPA-170-2153 granted on appeal to allow an alternative micrositing allowance and ancillary infrastructure layout and increase the proposed wind turbine tip height, amended description at land at Margree near Homehead, St John's Town, Rye. Section 42 application, reference number 25/0825/S2042. The recommendation is approved subject to conditions, and the case officer Neil Simpson. So Neil, can you take us through your presentation, please?
Yeah, thank you, Chair. Good afternoon, everyone. Congratulations on your stamina to date. This is another Section 42 application. For the avoidance of doubt, there was a previous Section 42 application that was approved at the last planning committee. That was for this site. That was 250218, Section 42. That consent, which was approved by the members at committee, allowed for the change in the micrositing. This is a separate but similar application, and I want to be clear to the members what it is that is being proposed. Again, the applicant is seeking the same micrositing allowance as was approved under that previous application. The main change, the other change that's sought under this application is for an increase in the turbine height from 200 metres to 220 metres against the original application that was approved under the appeal that the chair has just mentioned. So that was appeal PPA 170-2153. The matter before the members, therefore, is given that they approved the micrositing, is the variation in the height, whether that's something that they would be willing to approve. The plan you have in front of you shows the existing site layout as approved with the micrositing that's been allowed. Is it this screen or the next screen? If you want to advance the screen. Yeah. So this is the change in the micrositing allowance that's been approved under the previous section 42 that was approved last month. Again, that is what is sought under this application. Now, again, for the avoidance of doubt, were the members to approve this application, the change will be the increase in the turbine height, but the members have reserved rights to refuse this application, in which case the fallback position will be the previously permitted section 42, which allows the micrositing only and no variation in height. There have been no timeliness objections and no statutory objections to this application. There were 5 late representations at the time of writing my report. I believe that's now 6. Most of those representations relate to the impacts on the environment, ecology, and peat, and on the basis that the application should be a full application, given that it's changing the height of the turbines. That's, I mean, the members might want to seek legal advice on that again from within the room. My report's on the basis that it's a variation of the condition which was set out originally by the appeal, by the determiner, and the applicant has the right to vary the height. SEPA have responded on the basis of the peat matter. There is written confirmation from SEPA that they are satisfied that the subject to conditions that the application has been assessed to not be harmful to the peat. All the other statutory consultees have also responded that, subject to conditions remaining in place, that they have no objections. The basis of the application, therefore, and the determination, and my recommendation, is based on an assessment of the change in the turbine heights and the impact on the landscape. The important matter I'd want to bring to the attention of the members is, since this appeal decision, the adoption of the wind farm landscape sensitivity study has changed the assessment for this area where the turbines are located, and it has lowered the sensitivity. For large turbines, therefore it's not considered as sensitive to large turbines. Therefore, the assessment is it would not be reasonable for us to overturn. That was my advice, is it would not be reasonable to overturn the decision of the appeal. And if you want to proceed to the next screen, the next screens are based on the landscape and visual impact assessment as submitted to the original application, and it's providing a comparison of the consented scheme with the new schemes. So for each viewpoint, there's 15 viewpoints. Viewpoint 1, this is the consented scheme, and if you move on to the next scheme, next slide, this is the proposed scheme. So it gives you an idea of the difference that's going to be perceived. And if you click further forward, you'll have the same for each viewpoint. So this is viewpoint 2 from the minor road near Auchenshinock, proposed scheme, and the next viewpoint from Boagmore, again consented proposed, from Coolmark Hill, consented proposed, and this gives members an idea of the difference that would be seen from these viewpoints. Again, very distant viewpoint from the tourist routes. Just keep going. There's a few more. Again, so on the basis that it's not considered that the increase in height would be significant compared to what's already been consented, my recommendation was to approve the application, but I commend the application to the members. That's it. Thank you.
Thanks very much, Neil. Any questions for our case officer? I think you're in luck, Neil. In that case, members, thanks, Neil. We're in session. Councillor Driver,
Thank you, Chair.
please.
Thank you, members.
Agree the recommendations, Chair.
Thank you. Members in hall are nodding, so thanks very much for being here, Neil. That application is agreed as per officer recommendation. Can you affirm the decision of the committee, please, Tracy?
Thanks, Chair. Members have approved the application subject to conditions in the report. Thanks.
Move on to agenda item number 12. An application for planning permission in principle for the erection of a dwelling house class 9, formation of vehicular access onto C39A public road and installation of septic tank soakaway at Seafield Farm, Seafield Road, Annan. This is a planning application for permission in principle, reference number 25/1202/PIP. Recommendation is to refuse. Case officer was Iona Brooke, but again, Rachel's going to take us through this presentation. Just whenever you're ready, Rachel, please.
Thanks again, Chair. Hi, councillors. This application, as stated, is for the provision of a dwelling house with the formation of a road on land at Seafield Road, Annan. The application is before Planning Committee as it was subjected to a call-in by Councillor Crothers. Turning to the slides first. The location plan of the proposed site, please note in particular the size of the red light in relation to the 4 dwellings that are further down the road, known as 1 to 4 Seafield Road. The application is in principle, so these plans are indicative only of development which may occur should Planning Committee find this application acceptable. Again, indicative elevations. This is just to show what any development may look like. This is from the approximate vehicular access of the site, looking north towards Annan, looking south towards the coast, looking towards the site from the access road of number 1 to 4 Seafield Road, back towards Annan. This is the view from within the site, just panning through the site on these ones. Looking south, you can see Seafield farmhouse to the right of the photo. And then the proximity of the site in relation to Annan. So the site has a handy red arrow pointing at it for you. You can see that it is in close proximity to Annan, although outside its boundaries. And again, just to make it hopefully a little clearer, the position of the site in relation to Annan, the farm is actually would be at the bottom, but is actually off the extent of the slide. So, the application has previously been considered by officers under reference 24/1430/PIP and thereafter by the local review body who upheld the decision of officers. The reason for refusal previously is repeated in paragraph 1.5 of the report. The plans and information submitted at that time are largely unchanged from those previously considered. As an application for planning permission in principle, it is only the principle under consideration in this application. The applicant has consistently been advised that there is no overriding operational need for a further dwelling in relation to the farm. Paragraphs 4.6 to 4.7 of the report note considerations officers undertake when considering these applications. There have been 2 further applications under 23/2229/PIP and 22/0690/PIP, which also gave the same advice in relation to need. The application is accompanied by a labour report which outlines the need for 2 labour units, or people as we call them, in relation to livestock, with the remaining identified need contracted out. The report notes that the proposed house would be for an unidentified worker who is not currently employed by the farm, as only 1 worker is identified as the only labour on the farm. This is the applicant who resides in the farmhouse. This is discussed in paragraph 4.8 of the report, which outlines the consideration of the supplementary guidance requirements. No consideration has been given through the application to the potential of housing within Annan. As you have seen on the presentation slides previously, whilst the site is outside the boundaries of Annan, it is approximately 0.8 miles from the proposed site to the farm and only a further 0.3 to Anneley Road in Annan. It is considered that a worker living in Annan would be reasonably located in relation to the farm. Paragraph 4.11 outlines that no case has been put forward in relation to succession planning. Again, if this were to be the case, there is no information put forward to demonstrate why dwelling in Annan would be unacceptable. Paragraph 4.12 concludes that there is no established need demonstrated in the submitted documentation. In relation to the siting of the proposed house, the land is out with the flood affected area in this location. However, this does result in minimal impacts in relation to security and stock protection for the farm as outlined in paragraph 4.14. The limited benefits of the proposed dwelling are not considered to outweigh the fundamental conflict with the requirements of the local plan and MPF4 in this regard. Paragraph 4.19 to 4.21 clearly outlines these conflicts. The application is therefore considered unacceptable in principle. Turning briefly to other matters, paragraph 4.25 considers the lack of boundaries in this location, its prominent nature and how it would lead to sporadic development in the open countryside. As touched on in the presentation, the red line encompasses a site which is significantly larger than the nearest dwellings at 1 to 4 Seafield Road. Paragraph 4.26 outlines that any dwelling should reflect the needs of the business and not personal needs. The farmhouse has an existing 5-bed dwelling. Paragraph 4.27 notes that no occupancy conditions can be applied in relation to any dwelling proposed. The remote nature of this site from the farm increases the potential for general occupation of this property to occur, particularly as there are no labour requirements on the farm and no labour on the farm who currently requires this accommodation. This application would therefore result in an open market dwelling remote from the farm with no overriding justification being provided. It is concluded that whilst the supporting statement notes that, in quote, the additional accommodation is essential to assisting in advancing and expanding the business to meet future needs, no evidence has been submitted in regards to this, based on the existing needs of the farm, which are the only needs we can assess. On the basis that the application has previously been refused, that decision has been upheld at a local review, and that the current application does not raise any new issues or provide any new compelling evidence, the application is recommended for refusal for 3 reasons, those being lack of need, unacceptable siting and loss of good quality agricultural land. Thank you.
Thank you very much, Rachel. Any questions for our case officer? If there are none, we have one written represent. Oh, Councillor Driver. Councillor Driver, please.
Yeah, thanks, Rachel. I mean, I was on the LRB and Jim, we went on a site visit as well, and I think we all agreed as the LRB that it was up for refusal. So I'm just wondering, is there any change to this application compared to the previous one? I can't see any, and I'm kind of wondering what the issue is here.
I think there's a slight change which justifies it being submitted, plus the fact that it was called in by an elected member, which takes any decision making out of the hands of the officers. But can you help, Councillor Driver? Is there any material change or any significant change in the application, Rachel?
There's no fundamental changes to the information that was provided. As stated by Councillor Dempsey, it's here because we couldn't refuse to determine it because it was subject to a call-in.
Content with that, Councillor Driver?
Yeah, thanks.
Thank you. In that case, we have a written statement from Councillor Crothers, who will not be present today. But Tracy, can you read out the statement, please? And I take it will be 3 minutes because it's a local application. So just whenever you're ready, Tracy. Thank you.
Thanks, Chair. I ask for this application to be removed from delegated powers because it raises a number of important policy issues that merit full consideration by committee. This is not a straightforward case, and given the history of previous applications, I believe it is right that members make the decision collectively and with the benefit of all evidence before them. Point 1, site location and flooding constraints. In earlier applications, the application sought to locate the dwelling much closer to the farmhouse and steading, which would normally be the preferred and most logical position. Those applications attracted support in principle. However, because of the recent changes to national flooding policy, both SEPA and our own flood risk management team raised objections to the earlier proposals. This left the applicant with no realistic option but to select the site now before us. In other words, the location we are considering is not the applicant's first choice, but is the only viable one in light of updated national flood guidance. Members should weigh that carefully. The essential need for a dwelling house is unchanged. Only the siting has been dictated by external policy shifts. Point 2, labour requirement and essential need. The labour report is central to demonstrating essential need under policy H3 of our local development plan, policy 17 of MPF 4. From my reading of the officer's report, this important evidence appears to have been given limited weight. I am also conscious that some of the most compelling details within the labour report may contain personal or sensitive information that is not publicly available on the planning portal. For that reason, I believe members may not yet have the full picture, and I would therefore ask that we consider deferring decision to allow these matters to be presented in the most appropriate way, whether in private session or through further officer advice, so that the need can be properly and fairly assessed. Point 3, importance of a site visit. Finally, members will know that the site visits have taken place on earlier applications, and I would strongly urge that we take that opportunity again. Seeing the land firsthand will allow members to appreciate the practical reasons behind the site selection, including the constraints posed by flooding risk, and to judge for themselves the relationship of the proposal to the wider holding and surrounding landscape. In summary, members, this is a case where the agricultural need is clear, but where changes in national policy and technical constraints have forced the applicant into a less controversial solution. I ask you to take account of the context to seek further information that's required and to agree a site visit before reaching a final view. Thank you for considering these points in my absence. Next Chair.
Thank you very much, Tracy. Now that we've heard the Councillor Crothers' representation and his views, we're in session. Councillor Driver.
Yeah, thanks. I don't need another site visit. I've already been doing it, and I go for walks along that particular area. What I would say is I agree totally with what the officer is recommending in the report, and I would put a motion forward to support that.
Thank you. Councillor Hislop.
Chair, from the information we have in front of us, I don't think there is a need for a house at this site. And I think you have to demonstrate why it has to be on this site. That seems to be the stumbling point. And that information needs to come forward to allow us to consider that. But if there's no information to say why it has to be on this one site, then I think we're sort of stuck with the fact that it's not needed here at this specific site. So I would have to second Councillor Driver on this one.
Thank you very much, Councillor Hislop. Any alternative views? In that case, can you confirm the decision of the committee, please, Tracy?
Thank you, Chair. Members have agreed to refuse the application on the grounds detailed within the report. Thank you.
Move on to agenda item 13, an application for the cleaning of war memorial. On, aye, is it? Yeah. That's what I'd missed an agenda item. An application for the cleaning of war memorial at site outside St John's Scottish Episcopal Church, Newell Terrace and Lovers Walk, Dumfries. Full application, reference number 25/1261/full. Recommendation approved subject conditions. Case officer was Lindsay Little, but Chris McTeer's taken us through this presentation. Chris, whenever you're ready, please.
Thank you very much, Chair, and good afternoon again, members. This application is in front of you this afternoon as the application has been made by Dumfries and Galloway Council. So on the location plan, you can see that the application is on the application site rather is on the pavement outside St John's Episcopal Church at the junction of Newell Terrace and Lovers Walk in Dumfries, which will be familiar to anybody who's walked from the train station into the town. It occupies a fairly prominent position there. The planning application seeks permission to clean the memorial using a combination of water and brushes, but most importantly, no chemicals and no pressure washing for this one. The memorial will be left looking clean. As you can see, it's there's some discoloration and algae and dirt build up on this, but most importantly, it's not going to look brand spanking new. It's going to look still with its sort of slightly weathered appearance. So as you can see, there's the detail there. So the key issues raised with this is that the methods proposed are acceptable. It is going to improve the long-term appearance of the memorial, and it's recommended for approval subject to conditions, and I'm happy to answer any questions that members may have.
Thank you very much, Chris. Questions for our case officer? Doesn't appear to be any. We're in session, members. Councillor Driver.
Thanks, Chair. I totally agree with the recommendations within this, even though I am not I'm not responsible for war memorials in my Armed Forces Champions role. And I'll reiterate what I said earlier on. Some people think I'm in charge of war memorials. I'm not. I'm in charge of looking after people who require it from the Armed Forces.
Thank you very much for that observation and for your views, Councillor Driver. Councillor Barretti, please.
And I agree with the officer recommendations, Chair.
Okay, then alternative views. Councillor Hislop.
I was just going to say, if Archie's needing me to carry a bucket of water along to help him wash it.
I would be careful with that, Ian. So, can you confirm the second committee, please, Tracy?
Chair, members have approved the application subject to the conditions in the report.
Thank you. Move on to agenda item 14, an application for the installation of replacement flat roof covering at Kirkinna Primary School, Main Street, Kirkinna. Listed building application for listed building consent. Reference number 24/1249/LBC. The recommendation is to approve unconditionally, and we have a brand new planning officer team member with us, Archie Montevoy. Well done, Archie. Congratulations on your progress to the Planning Applications Committee meeting. Archie, Councillor Driver says Archie's a very good name. So I'm sure we'll be gentle with you, but we're looking forward to your first presentation, Archie. Just whenever you're ready. Thank you.
Thank you, Chair, and good afternoon, members. As the Chair said, this application seeks listed building consent for the installation of a flat roof covering at Kirkinna Primary School, which is a Category C listed building. The school sits on the northeastern side of Main Street, or the A746 that runs through Kirkinna. No representations were received in relation to this application, and it is in front of members today as it is being done by Dumfries and Galloway Council. This slide shows the 1 to 1250 location plan on the right, which shows the primary school in relation to the surrounding village, while the 1 to 250 site plan on the left depicts the site boundary and the site itself in more detail. This is the proposed site plan, which shows there is no change to the property on the whole. However, it does clarify where the contractors will have their storage, parking and welfare area, as it is outlined by the blue dotted line to the east of the site, while the green dotted line shows the path the contractors will take from the welfare area into the school and vice versa. There is also a light orange coloured area which shows where the flat roof is and where the work will be carried out. To give some context as well, within the listing there are some alterations that have been described as unauthorised or regrettable. The flat roof is one of the regrettable ones, as it is done at a later date to form a link between the two traditional buildings. On the left we have a 1 to 100 drawing of the entire roof plan, which shows the light orange colour again where the work will be carried out, and on the right hand side you've got a 1 to 50 drawing showing the portion of the roof, showing the existing portion of the roof where the work's being carried out. This is the proposed roof plan at 1 to 50 with the work being described carried out. The existing flat roof is a felt roofing system, whereas the proposal seeks consent to change this to a GRP Polyroof Protect waterproof system, as the existing roof has suffered significant failure which has led to leaking. The proposed roofing system will provide a fix for the existing leaks, but should also be able to adequately combat the weather and prevent future leaks and damage. Onto the photos now, and this is a photo that was submitted by the applicant which shows the current state of the existing flat roof. This is a photo that is taken facing southeast along the A746 and provides some more context of where the school is in relation to the rest of Kirkinner. The flat roof is located mainly behind this elevation we're looking at. This is a photo facing east on the opposite side of the road to the primary school. Once again, the flat roof is on the opposite side of the school to this elevation. It's a photo facing northwest, and this is mainly the side where you'd see the flat roof, but it isn't very visible from this side. And this is also the elevation which is the main entrance to the school. This is a photo facing northeast along the A746 and provides some more context to the siting of the school. And once again, you can roughly see where the flat roof is, but again, not all that visible from this angle. The key issues with this one, the main concern is whether the impact this proposal will have on the Category C listed building. But as mentioned before, the portion of the roof set to be replaced is largely hidden from view, meaning it should have little effect on the rest of the listed building. The existing roof is also described in the listing as regrettable and has now failed, meaning it needs immediate replacement, and therefore it is recommended for unconditional approval. Thank you.
Many thanks, Archie. Any questions for our case officer? Councillor Campbell.
Thanks, Chair, and thanks, Archie. I'm just wondering, when they take the felt off and they discover any remedial work, would that require a further application?
Archie.
Not likely, no.
Thanks, Councillor Campbell. That concludes questions for our case officer on the session. Councillor Campbell and Councillor Hunt are not in agreement. Councillor Dryborough.
Agree with the recommendations, Chair.
Thank you very much, Councillor Dryborough. Councillor Barretti, Vice Chair, has also acknowledged that. So can you confirm the decision of the committee, please, Tracy?
Chair, members have approved the listed building consent unconditionally. Thank you.
Thank you. I have two very minor pieces of additional business, and one is the agreement last month that I would speak to governance about whether or no we could revert from our CLAT reading a considerable amount, or it was advantageous to having them placed online or circulated to elected members. That's been raised by Head of Governance, and he has spoken to David, Tracy and Laura, and will receive an exact response, hopefully prior to next month.